Oh, enggak ada. Bottom dulu. Kalau begitu biasa. Oh, problem sana. Orang itu. Ribut kan manually pun ada. Manually pun ada.
Connection.
Yes. So one, the death certificate has been verified to be correct.
The death certificate, name of the deceased is shown as Bolainia Chaudhary. There is the Bolainia,
Son of?
son of late Imtaz Ali, but here late Imtaz Ali Chaudhary. And your lordship address also international. The death certificate is showing as Kali number 52 Algapur, Hailakot.
And the other one of the convict is absconding. Yes, who is joining from? Harimanj, who is joining? Yes.
Debojit Rai, my lord. Addition.
Mr. Roy.
Addition big, my lord.
Yes, you're.
My lord, Moinuddin and Abdul Malik are present in custody. Bolainia expert report is there. And regarding Ashik Ali, police submitted, my lord, report dated 5 5/4 last date, 5/4/2025, and today yet to be received any report. And officer in charge of the police station informed over telephone that due to alert duty and he is unable to appear, and also other police are busy in alert duty, so TR is to allow them for appear in the next.
Okay, what about the your colleague here in the High Court has made a submission regarding the death certificate, that there is mismatch of the names as well as the name of the father. Have you checked up that that issue?
There is no any issue.
No. Do you guys are you in possession of the concerned relevant documents? Do you have a copy of the report?
Yeah, copy of the report is there.
Yes, kindly see what is the name of the father.
Death certificate. Oh, death certificate or death report is online.
Yes, come to the death certificate.
Death certificate, Bolainia.
By Mia Chaudhary.
Pabul,
Great Indra Ali Chaudhary. What is your submission, madam? What is the mismatch? Balai Mia.
Yes, on the Bolainia.
Indra Gandhi.
There are two discrepancy which has been pointed out. In the criminal appeal, it was Bolamia, not
Bolamia.
Bolamia Chaudhary. Number two, father is in Intaz.
Imtaz Ali.
Now it is Indraz.
Imtaz.
Mother is the same, I think. But mother, of course, in appeal there is no mention, so we cannot ascertain from the name of the mother.
Only his case match.
Indraz.
Indraz.
Online of the time.
Online or same Indraz.
Oh, again. Oh, name, mother, name, father.
Indraz Ali.
Recorded 45 years as of 1997. He expired on 16/9/17 and his age is
63 years.
That is going to be-
No, there
7 years, 45 years.
no rural person or rural areas that may not be strictly 1 or 2 years difference is there, but we have to ascertain that is whether it is the same person. Yes, is it the same person, Mr. Roy?
My lord, regarding this, there is no any report from
So the
the.
verification is only with regard to the death certificate.
Yes, yeah.
That has been put to rest that there is the death certificate, the duplicate is also verified to be correct. But whether it pertains to the accused convict, that we need to ascertain.
Yeah.
Is there any mechanism? Have we ascertained that part?
No, yeah.
Case recorded.
It is a certain
Case recorded filed by Indra Elias Intaz. It will go sold होता. होता है. मैं तो बिल्कुल के बिल्कुल नहीं देखता.
Intaz or Indraz?
The fellow is just a party. Intraj. Intraj.
Intaz and Indraz.
Indraz.
Regular Intraj.
Indraz or Indraz.
Intaz, you know, to Intaz.
Indraz.
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 You know,
Indra
Intaz.
Intraz होते हैं.
Indraz.
IND.
DRF. Indraz.
पूरा होगा इस. Location सुनानी.
Location
So,
Kalinagar.
Ini sih tu mulai mesin.
why is it?
This is the pepper. This is the Bolamia, son of late Indraz.
Indraz.
Here Indraz.
See, at times while recording also, we are not imputing anything, but it may be due to oversight or inadvertence. The names we find, even the name of the person who is signing, he signs in a different.
Yes, yes.
We have seen these are practical realities, but we have to make an endeavor that this kind of thing does not happen. But the underlying aspect is that we have to ascertain that whether it's the same person. Names here and there will not make too much of a difference.
Then somebody will think more or less think that.
No, so far as the absconding convict is concerned, we have decided that we'll pass the sentence part will pass so far as the others are concerned. For him, we'll pass an order making some observation. What other course of action can be taken? That is one. But regarding this person who is said to have been passed away, for that, what do you suggest, Mr. Chaudhary? one verification, let it be done, whether it pertains, so far as verification of the authenticity of the death certificate, that part, we may express our satisfaction. But whether it pertains to the same person, rather, I think that will be good.
Yes, Lordship, and at least if the officer in the district administration is interested to make the verification,
Yes,
I think that will be more authentic.
yes. The concerned OC of the Thana can make the verification. The only verification of the person, why do you need?
This is very good.
Trust the officers.
Very good, isn't it?
No, he will take reports. The OC will make an inquiry. He can take reports from all concerned on the authenticity of that, whether this is the person. Okay, I think we'll grant around, we'll fix this case around after maybe around 15 days. Just a minute. Today, 5th. This court may not be there for 2 weeks from next week. So we'll have it on 26th. Enough time will be giving. 26th. Sir Roy, 26th. Please ask your officer to make an inquiry.
My lord.
And while making the inquiry, he'll have consultation with the local people, the Gaungura, and whether the name of the person who has been, which is reflected in the death certificate, is the same person who was a convict, who was an accused in the police case and ultimately led to his conviction. Heard. Yes. We have learned Senate Council as well as APP for the state of Assam. Also heard Sri D. Roy, learned APP, appearing online. Learned APP, Karimganj. So we call it Sri Bhumi, appearing online. Sri A. Chaudhary, learned counsel, appears for the respondents. We have also heard Sri B. M. Chaudhary, learned amicus. Ms. Bhiya, the learned APP, has referred to a report received, a report issued by the Additional District Judge Karimganj to the registry, Additional Session Judge Karimganj to the registry of this court on the aspects of the death of one of the accused convict, namely Bolai. What is his name?
Yeah.
Bolai Mia, alias Monai Mia. Correct? The issue of apprehension of accused oblique on a convict oblique Casper number 1 Ashik Ali was also one of the points which has been covered in the report. As per the said report, in spite of the efforts made by the police, the same accused oblique convict Ashik Ali could not be apprehended. So far as the verification of the death certificate is concerned, though there is a satisfaction expressed that the duplicate certificate has been verified, Ms. Bhuya, the learned APP, has submitted that there appears certain discrepancies both in the name of the deceased as well as the name of his father. Noticing the said aspect, we Sri Roy, the learned APP appearing online, has submitted that due to law and order duty, the concerned police officials could not be present today, could not be present in today's proceeding. Full stop. Sarah. considering the above, comma, we direct the concerned, direct the officer in charge of the concerned so-and-so PS to make an inquiry as to whether the death certificate pertains to the accused public convict Bolaimia by in the said inquiry, comma, the concerned Gaambura and other respectable citizens of the locality are to be consulted and their statements recorded. The report is to be furnished within a period of 2 weeks to the office of the learned session judge Karimganj, who would accordingly transmit the same to the registry of this court. List this case for consideration on 26th of May 2025.
Additional session, yes, sir.
Addition. We're fixing it on 26 and on the same date, an up-to-date report on the aspect of the efforts made to apprehend the absconding accused public convict be also placed on record.
No,
Yes. The other persons who are in custody shall remain in custody till the next date. Until further orders. Okay. So we are fixing on 26th of May.
Still work. He just will take it.
It was decided to step today, it was maybe on Friday.
Wait, fresh matter. Whenever you want.
Friday. And another thing, I have filed one additional request to bring on record that one of the person who is in custody of the criminal appeal is seriously ill and admitted in hospital. I is also pending, so that also will be taken up on Friday. That was already directed to be listed to the idea.
When did you file the additional affidavit?
That was filed on that exact date is not very clear.
Now, how many days around?
The appeal is pending for
No, the additional affidavit.
around more than 1 week.
Okay, then Friday.
All right.
Yes. Matter, madam. Hearing 16 matter, we're in 2025. How many years? 9 years. And outside you will say matters are pending. Why do you seek time? 16 matter, don't you feel that we should not seek time at 16 matter unless there is grave urgency? 9 years. On Monday next.
I was at length on many pages, but then somehow it could not be, the judgment could not be delivered. Otherwise, it was.
9 years, 9 years, 4 months, he's inside.
In fact, once it was heard and almost judgment was supposed to be delivered, then it was found out that the informant was not served with the notice. Thereafter, it was found informant is dead. So that again got, the matter got.
Okay, and Monday next.
Monday. He always said, don't be yesterday.
Okay, then Tuesday next. Tuesday. No, you make alternative arrangement. You cannot adjourn matters like this at your own wish. If there is an urgency, yes, 1-2 days. 16 matters are not going to adjourn till June. Sorry. A prayer for adjournment has been made on behalf of the appellants. We have, however, noticed that the criminal appeal is of the year 2016, and therefore the prayer does not appear to be reasonable at all. Para, be that as it may, in the interest of justice, today's proceeding is adjourned, and the matter is directed to be listed for hearing on 13th. On 14th, okay, 14th. 14th. 14/5. Yes. Yes. Matrimonial, provide it for orders. You see the records, may not be a case for adjournment if it's for steps doing the direct. Okay. You see the records, we'll pass orders, don't worry, see the records. You'll be here when the matter is called. Yes, next. Yes. Who's for the other side? Okay. The learned counsel for the parties have jointly submitted that the mediation proceedings are going on and some time and the matter is required to be adjourned to enable the parties to make an endeavor to reach to an amicable settlement. Para, in view of the said submission, the matter is adjourned by 1 month. Vacation today around 5th. Vacation starts when? Vacation is at the end of June. Who is by a month, and which is and a month. Let the matter be listed on 25th of June. If you need more time, we'll grant them. Okay. 25th of June. 25th of June, or by which date the up-to-date status of the mediation proceedings be informed to the registry and be informed. Yes, registry knowledge. Good morning. By the husband. The grounds, what were your grounds? Ground for no, what are your grounds in the desertion and dismissed why?
Because it is filed related after 40 years.
40 years. What is your age? 71 years. 72. Huh?
Below from the 10 line below.
It was contested. Heard 3 SK, whose learned counsel for the appellant who has preferred this appeal under section 19 against Swinson by the aforesaid judgment and decree, the suit filed for divorce on the ground of desertion has been dismissed. It will go against judgment and decree, it will be dismissing the suit and para admit call for the report. That steps be taken for service of notice upon the respondents be taken by registered post to TD. Steps within 2 days, 2 working days. Item 2. .302. Jail appeal.
Yeah.
Okay, 302. President normal admin, call for the record for A Begum. 6 weeks. And that's the good bank MFS. In this appeal prepared from J, we appoint. Company support. 6 weeks. For service of for report on receipt of. Respond now to my okay. Item number 3.
And my name is Dr. Anity Soles against Guwahati High Court. It's wrongly sold as Guwahati High Court.
First time it has been listed. And you are already appearing after condemnation of the law. Third, Ms. B. Sharma, learned legal aid counsel for the appellant who has preferred this appeal on the so against so. Admit, huh? You take any legal? Ms. A. Begum, Kate, and Ms. L. Devi, legal aid counsel, has appeared for the respondent to informant who had already appeared in the application in IA number 7, which was filed for condonation of delay. It however appears that in the cause list, the cost ID has been written as so versus Guwahati High Court. The the cause list should be correctly written as so versus State of Assam and another. Further, the name of Ms. B. Sharma, learned legal aid counsel, be reflected in the cause list as counsel for the appellant. 6.6 for service of report on LCR, TCR.
Item 4. Hearing on behalf of Mr. Agar, he has been appointed as chemicals in this matter. These are chief and has been notified to the.
Okay, well, yes. Is there any response number 2? No, that we have seen. Is there any response number 2? Conviction under 302. Okay, we'll have this for hearing then.
Yes, the matter has been received.
The paper book is already prepared. Have you received paper book?
Yes.
The paper book has been prepared and furnished to the learned counsel for the parties. Sarah, list this case for hearing in the month of in the first week of June 2025. Matter of 2020.
Item 5.
My lord, in respect of the original property, the subject is completed.
Madam Das is appearing for her too. Yes. You can remove your strap. That looks like a part of the uniform. You can remove it. Is it necessary to wear it? Well, small or big bag doesn't look good. And that too across. Like a parachute. Okay, paper book is, you have been served with the paper book. Hard. Jed Hussain, learned legal aid counsel. Amicus, you are not legal aid counsel. Legal aid counsel. Also heard. Ms. S. Jahan, learned APP. Ms. M. Das, learned legal aid counsel, has entered appearance for the respondent to. While the paper book has been prepared and copies thereof have been served upon Sri Hussain and Ms. Jahan, the same has not been served on Ms. Das, the learned legal aid counsel for the respondent to. Ms. Das, no, the copy of the paper book is accordingly directed to be furnished to Ms. Das, for which necessary coordination be made with the office. Clara? Of which year 22? List this case for hearing in the second week of June 2025. Names of everybody is shown in the court list, yes.
Yes.
Item 6. Yes. Paper book has already been prepared. Is it a regular appeal or a jail appeal? Huh? But steps are directed to be taken by registered post as well as usual process. After ascertaining the address, the informant from the LCR, were steps taken? When?
Not through the duty office, and it's a policy matter.
You take first steps, okay, and by the manner prescribed, and madam will send it to the concerned PS for serving upon the informant's mother.
For this was fine for the.
Nayak, 22. No, still there, since there is no report of the service. Though this appeal was admitted on 26/8/2022, and steps were directed to be taken for service of notice upon the respondent to. Though the paper book has been prepared, there is no report on the service upon the said respondent to. In the interest of justice, we direct the learned counsel for the appellant to take fresh steps, which is to be routed to the office of the PPS1, as the matter involves conviction and sentence under the POCSO Act. Let steps be taken within 2 working days. That this matter be listed after 3 weeks, so as to enable Ms. Jahan, the learned APP, to obtain the instructions regarding the service affected on the respondent to. Item 7. Yes. I think you need to take fresh steps, okay? Your name? What is your name? A.H. Part 3 A.H. M.R. Chaudhary, Learned Council appeared on instruction of Miss R. Mumtaz. R. Mumtaz, Learned Council for the appellant. Those steps were taken both by usual process and registered post AD. The report has not been received. Full stop. Since such steps were taken way back in the year 2023, we direct the Learned Council for the appellant to take fresh steps by registered post AD. Full stop. List after post AD within 2 working days. List after 6 weeks along with fresh service report. Full stop. If while preparing the note on service, the postal track report may also be indicated. Item 9. Item number 9. AM Doctor. Yes, sir. Anup Rinal. What about the records?
Records are here.
This appeal was admitted on 29/1/2025 and pursuant to the order passed, the TCR have been received. TCRS have been received. Let the paper book be prepared and the appeal be listed for orders after preparation of the same. Close to fix the date of hearing. Item 10.
In the facility office, if that paper, we don't get any papers.
That's right.
So, online notice already signed respondent number to my lord, then it not a API and then report came.
Objection should find.
Objection, so we trade for my lord.
But has been served.
Sir.
124. Okay. House 3C Goswami Learned Council for the applicant appellant as well as Ms. A. Begum, Learned APP Assam, Para. Carried the order passed by this court on 27/1/2025. As the respondent number 2 has not appeared and the matter and the impugned conviction and sentence involves the POCSO Act, we appoint legal aid or amicus. We appoint Sri Abhijit Bhattacharya, learned amicus curiae, learned counsel to act as the amicus curiae for the respondent number 2. The name of the whose name may be reflected in the court list henceforth. Sri Goswami, learned counsel for the applicant appellant. He is directed to serve a set of the documents to the learned amicus curiae by within 2 working days. Let a copy of this order be served upon the Bhattacharya by the office. Item 11. 11.
SCR is here, the POCSO matter, right? Yes.
No, 302.
Subsequent order for fresh.
I got the remark to the DCL, same order, huh? Same, exactly. Item number 9, same order. Okay. Item 12.
We have not filed our objection.
I is also there. Supplementary file sum. Pursuant to the order dated 19/2/2025, steps for service of notice upon the respondent number 2 were taken, which were accordingly issued by the registry of this board. Full stop. Peruse the materials in the supplementary file as indicated in the office note dated 1/3/2025. There is, however, no report from the concerned OC. Full stop. Registry to give requisition to the concerned OC for his report on the aspect of service of notice. List after 4 weeks. In the meantime, objections, if any, may be filed both by the state and the private respondents on his or her appearance. Who's respondent 2, madam? On his appearance.
Name is same.
Huh?
Viram Das.
Oh my God.
Some sir, fathers are different.
Is that the reason of killing? How can he have the same name?
Yes, same name.
Viram Das. He is Robi. Here he is Rabi. But in the appeal, I think you have both made Rabi.
Yes.
Okay. Item 13.
Delay for the certificate. Delay of 107 days.
First time.
Perfect.
For Miss D. Borpujari Learned Legal Aid Council
Legal in person.
for the applicant. Okay, for
Certificate for the delay.
Learned Legal Aid Council. Who has filed this application under section 5 of the Limitation Act for condonation of delay of 107 days in preferring the appeal. So the appeal has been preferred against self-defense. Correct? Also heard Ms. S. Jahan, Learned APP, Assam. Correct? Ms. Borpujari, the Learned Legal Aid Council, has submitted that the appeal has been preferred from JV by her as a legal aid counsel. And the delay has occasioned as there was none in the family who could help the appellant to prepare the appeal. She has also submitted that the petition application by the applicant was forwarded to the Legal Services Committee of this court, whereafter the same was handed over to her for preparing and filing the appeal. And in the same process, there has been a delay of 107 days. She has submitted that there is no laches or negligence on the part of the appellant. And the delay has occasioned because of reasons not beyond his not within his control. Sarah? Ms. Jahan, the Learned APP, has fairly submitted that since the appeal is against conviction, that too referred from the jail to a legal aid counsel, she would not have serious objections to the condonation of delay, and her objections would be on the merits of the appeal. Fair? It is a settled principle of law that while adjudicating an application for condonation of delay, a justice-oriented approach, justice-oriented and pragmatic approach is required. We have also scheduled the grounds assigned for the delay, and considering that the subject matter of the appeal is a conviction, we are of the view that the delay is required to be condoned, which we accordingly do. I accordingly stand allowed. The appeal may be registered and listed for admission after a week. Item 17, so please. There is 302, no private respondents. Is there? Not true. The modal service was not, you have not taken steps.
I have taken it.
Huh?
Yeah, I have taken it.
In the IA,
I
IA have not taken.
have one.
Hmm? There is no office. Where did you take steps? How did you take steps on R2? When?
29-1.
Yes. There's no reflection. Twenty-nine one, which year? Which year?
2024.
2024. This
Yeah.
came up on 21/8/2024. How could you have taken steps?
That's right.
That is not steps.
Yes.
That was filing date. The matter what come up for consideration in August 2024. How can you take steps in January 24? Then you
Have taken the last after notes.
Where? Show us. We are not saying that you have not taken steps, but you have to show us. You take steps. No, this you have given the wrong date. You have taken step. This is 28/11/2024. 28/11 after
Yes.
28/11.
29.
That is filing date 29/1. Okay. Part 3 other land counsel for the applicant, as well as we said Jahan Learned APP Assam Para. While the Learned APP has paid for some time to file the objections, comma. So far as the service upon the response number 2 is concerned, the Learned Counsel for the applicant has submitted that on 28/11/2024, steps were taken for service of notice upon the response number 2. Full stop. He has also placed on record the acknowledgement issued to him by the office to verify and indicate in the form of an office note the status of such service. Okay. List after 3 weeks, by which time objections may be filed. Do you have a copy of this, extra copy? You have? If you do not have, make a copy. In 18.
Yeah, in this case, what you yeah, so, I think the lordship may direct the registry to feature the paper. But I also there if it is not this paper is paper, I will not say. So I will take time.
Pursuant to the order of admission and calling for records passed by this court on 10/2/2025, the TCR have been received. Office to prepare the paper book and list the same for orders thereafter. Other side. Where is your name? Where is your name in the cause list? 5 to 12. Oh, Madam Das is there, so you are also there. Okay, who is for?
2348 Mubarak's name is shown, madam.
Where is Mr. A. Mubarak? Applicant secretary. What was the offense? I mean the trial was under what sections of law?
It's not section
302.
Yes, madam.
You are the informant.
Fine. My younger brother Muslim minor is by.
Okay. No, we intend to take up the matter, but where is Mr. Mubarak? Paper book is there.
Minor.
How many witnesses?
Minor, total 12 minor,
12.
according to the official English.
Eyewitness was also there.
This is one, they are minor, 1 to 7, minor 3.
All eyewitnesses.
Minor, trial court minor discarding that they are not eyewitnesses.
Now you say that all are eyewitnesses.
Minor,
7 eyewitnesses.
minor. Because incident took place in a minor craft area, matter. Nearby village, in the midst of village. They have come, they have seen only occurrence in the evening.
And what was the assault by weapon?
No, madam, that is not ascertained, madam. As per the FIR, madam, 3 persons, accused number 1, 2, 3, father and sons, madam. They have brought up in the mediation of madam.
No, what was the weapon with?
Weapon, madam, no, madam, no sitter, no weapon has been used, madam.
And
Only there is assault, madam,
And the nature of injuries?
injuries, no, madam. As per material, there is no extra.
No injury.
No.
Oh, then Viceroy was sent for FSL.
Minus 7 minus the extra also said that minus there is no such kind of general position. Minus test is clean.
Then what was the cause of death? Opinion?
Cause of that is minus natural minus natural death.
Natural death.
Minus.
No external injuries, no poison.
On the basis of dying declaration, madam.
What did he say?
There has been dying declaration, madam, while he was minor assaulted on his minor. Hearing his mother, even report came madam. Then he said that the friends of the company to this, they have assaulted me, madam.
No, if there is physical assault, there has to be medical evidence.
But
But medical evidence is not there.
That is missing, madam.
But dying declaration before whom?
Before minor, this not recorded, not before the police, not.
No,
before
not
before the people, madam.
People, they are witnesses.
Madam, no, it is a 1, 2, 3, 5 and 7, madam. Trial court is not believing, madam, that the right because it is doubtful, madam.
No,
On the-
IFSI, we may also think the trial court was on the right track, but unless you show us something else, if there is no medical evidence of any physical assault, no medical evidence of any poisoning, what was the age of the deceased?
Madam, I think young boy, madam, nearing, I think 25. Because there is a large because with the daughter there, madam.
No, those are okay, but what is the cause of death?
Minor cause of death, madam,
PM says what?
madam.
What does the PM say?
PM says, madam, this is minor, normal natural death, madam.
Natural death, then. Let us see the PM.
Is number, one, that's code 170.
The 179, madam. That external appearance is 179. Pilot, then wheels, only where pilot on that brain and spinal cord, pilot. Spinal cord is not examined, pilot.
This is not found.
The right lung also, pilot. Both lungs congested, one section, 4 repeat blood comes out. That is a doubtful one. There might be internal injury, though it is not opined by the doctor.
No, might be may not help you in a criminal case.
181.
Once you say might, it will go against you.
But because this doctor, so I cannot dispute. But
No, that is now, if there
popular
is
evidence does not support the final doctor.
if there is an aspect of might,
My,
then the benefit will go to the other side.
that is correct.
Had you been the appellant against a conviction, it would have gone to your side.
My. I don't.
Was
Healthy, stomach and something, there is something like.
There's just something, my lord. Yeah.
was healthy, because actually
HC hemorrhage present on the new star, right? There's nothing grams, there is liquid substance setting.
pungent smell.
That's my lord. That is not my lord. Cannot be a minor something minor. Maybe minor, there may not be breach minor, when some internal injuries cause minor.
No, let us see the visceral report, the chemical analysis. Let us see, where is that? That is why it is sent for chemical analysis to the FSL.
174.
174. So then there.
If negative test for common poison.
Down. What is your basis?
Basically, my lord, the minor. Statement, my lord, made by the disease reporter, cases, my lord, that he has been assaulted, he has been stopped by them and around them, he has been forced to put a signature in the documents to be married to his minor.
No, see, these, even without going to the veracity of this deposition,
Minor.
it may be correct, it may not be correct. But what connection does it have with the death? So far as physical assault is concerned, medical evidence is against you. The only support which is the aspect of something found in the stomach, that pungent smell. That also gets demolished by the report of the FSL, no poison. And that's, as per the doctor's evidence, is a normal, natural one. See, to argue against an order of acquittal is a very onerous job. There is already much more, already a presumption of innocence. That presumption has been fortified by an order of the trial court after taking into consideration all the evidence. And once that finding has been arrived at, to overturn that finding, your job is a very onerous one. We are not saying that acquittal against appeal against acquittal cannot succeed. It can succeed.
But burden is more.
Much more.
Minor.
Double the burden.
That's minor. But
That is why we have to us in what is the nature of the, how was it the
minor.
death has been caused.
By the time and that minor. This injury minor. These are
Injury is not there.
not that injury, but the internal.
Internal is also not proved.
Report minor. So there might be minor internal injury which does not show in the minor.
Internal injury will also be seen. That is why post PM is done.
That the opinion of the minor expert doctor is not minor. Differs from the minor evidence.
No, if it's a medical evidence, then medical, ocular and medical, there may not be consistency.
Minor.
But when it is an expert opinion, so far as the nature of injuries is concerned, we have to go. But so from the inquest also, if any injuries were seen in the inquest report,
No.
then they have seen, anybody has seen any assault?
They are saying, well, they are assaulting, not
No, no.
by the lathi on or something. Minor, not that assaulting. They are seen.
What kind of assault?
I think fist and blow.
Even fist and blow will cause injuries. which
That's
would
why
be,
minor, there might have minor internal injury that will not come in the minor. If postmortem.
no, see, if there are internal injuries, there would be hemorrhage, either in the brain or any part.
Minor.
That will definitely come. Everything has been examined in the PM report. Okay, we'll start.
With this says worship that there is a poison in his eyes and mouth.
Who says?
Uh,
That poison is coming, that's why. Because they are putting eyes and mouth minor. One is dichlorophene like minor, liquid poison minor.
How can you poison the eyes?
And the handkerchief and the bottle has been seized minor.
Bottle of what?
There, where it contains poison.
Examine.
Examine.
What was found? Perfume. Okay, we have to do it, yes. May not be necessary. But in the meantime, try to inform him. If he's not appearing, we cannot force him to appear. Yes, Madam, try to inform. If you know who is the counsel, you know. Right.
Well, there is one, my predecessor who was and it's a written argument matter.
Okay.
Okay. I will relay that also.
Okay.
In the annex or
Just give us 2 minutes.
Well, it is annex matter, and then I will provide it.
Just give us 2 minutes. And private respondents who are appearing, please give your names. For
What I feel is
224 Mubarak. Not appear. No. Yes, your name? Use it. You are on record. You are the mother of the victim. Lavanya is okay. Male.
Phase 4.
You said 12 numbers of PWs.
Mother, this is a paper book, mother.
No, 12 number of PWs.
Phase 4, the FIR matter, wrote by the matter.
Just a minute.
Lavanya Das.
Yes, phase 4. 10-3. 10-3, is it?
Mother.
Entry 2002.
My lord. Oh. Initially, my lord, the 6 personnel, my lord, my lord, people recorded, my lord. Thereafter, when the my lord, rest of the 21% my lord, 5 to 12 my lord. Again, under 19 of the CRPC, my lord, that will go, my lord. Again, my lord, 3 about 5, after 2006. In 2006, my lord. I started in 2004.
Yes.
Then 7 replacement happened minus recorded. Then during that those 21%, 5 to 12, their names appear.
Oh.
Then they have been minus by 19 minus.
Oh.
Then we take this person later. First is the minus first 21% father and 2 sons. It is one or four monos in 4.
This appellant informant is PW1.
Minus.
Yes, please read the other.
Married, madam. With due respect, I beg to submit that I am a permanent resident of Komartula Supuri of Borokala Gao under Cook Borbat Moza. My father name is Left Boncharan Das. In the evening of 8/3/2022, Sunday, while I was not present at home, Sri Kamrodpo Das and his 2 sons, namely Manoj Das and Urup Das, of the aforementioned village, forcibly took my youngest brother, Sri Pankaj Das, away from the house for some use, and therefore they threatened him inside Sohit Smriti Sangha at Borokala Gao, Komartola Supuri. Because of the aforesaid circumstances, I as a guardian took Pankaj to the house of my elder brother to Numati, Guwahati, and left him there in the morning hours 9/3/2002. But the boys mentioned in the Azhar again brought Pankaj from Guwahati, and after committing assault on him at about 11 p.m., they made him consume die from a kind of liquid poison and left him in the veranda of Sohit Smriti Sangha in a morbid state. Thereafter, hearing him of Pankaj, the neighbor people walked up and coming there with light, they found the Pankaj lying in morbid state, whereupon the boys entered in the house of the Pandarpo that run. Then seeing the condition of Pankaj to the critical, the villagers rushed him to the nearby Borua nursing home, Nalbari, and got him admitted there. But finding his condition to be critical, the doctors of the nursing home has referred him to the neurological nursing home, Guwahati. I therefore pray to you take necessary steps in this regard by looking in the matter and oblige. This is the affirmation where the my respondent number 3234 are specifically mentioned. Page 7, charge minor. Charge 10, first minor against Pandorpo Das and Manoj Das and Urup Das minor on 27/2/2004 minor.
In the initial the affair, Kondorpo and sons Manoj and Arup were named
Minor.
as accused.
Minor.
Okay.
Then
These accused are numbers what?
These are minor 5 to minor.
No, these are 2, 3, and 4.
2, 3, and 4.
Manoj, Kondorpo, Manoj, and Arup.
The father and son.
You are representing Mr. Sekia.
I am not the witness.
Oh, the Mubarak is representing. Oh.
He is for the letter implicated.
R, 2, 3, and 4. Okay.
Then
Just a minute, please. This was reported at 2:30 p.m.
minor.
Incident of 9/3 is at 11 p.m. Night.
Night. There is on part 8 also minor.
8, the
8 they have picked up
threatening part.
their training part.
He was brought to Guwahati.
No matter that's showing here. Then coming to know he brought his
Yes.
brother to his house.
No, he got him to Nurmati, Guwahati.
Next day morning, on 9. 8 also minor, there's a minor incident that Sunday, while I was not present, was brought to that showing just minor.
So that was 8 was the incident of threatening.
Threatening minor.
Threatening. Then he apprehending some circumstance, as a guardian, he took the deceased to his elder brother at Nurmati, Guwahati, and left him there. And therefore, and on 9th, and that was in the 9th morning. 9th morning, in the morning hours. Then boy is mentioned in the Azhar, came to Guwahati, brought him again and committed assault and made him consume the Diamcron. Eleven PM. 11 PM. What is Diamcron? What is Diamcron? Just check in your Google. DAIMCRON.
Spelling is minor, different misspelling, different.
Maybe. Whatever is the correct spelling, what is the meaning? What is the spelling? What is?
Here is for DIACRON.
No, if you say it is not a poison, Mr. Saikya says that it's a medicine for. Yes. Yes, what is the medicine?
This is for diabetes.
Diabetes medicine.
Well, I is coming up with that.
Because it doesn't, the signature of the. Mr. Saikya, kindly see the, Madam Begum, kindly see the records. Yeah, Jahar, it's in it's vernacular, I think, because it appears to be a translated one. But it is given in italics. Therefore, I think. Okay, yes, please proceed.
Fine. So these husbands come against only these cases for
Page.
Page 107 manual. The Conrad Kodak, Mohan Das and Arup Das. On 27 to 2004.
Charge against 30 to 34.
34 manual. Against Conrad Kodak, Mohan Das and Arup. Conrad Kodak, Mohan Das and Arup Das.
The named accused person.
Name accused person I have. Later on, my lord, we found 73,006. Next page, my lord,
Hmm.
the other accused person, rest of the accused person have been, my lord, implicated in that case as an accused person.
3 more. Koilas,
So from 8 more, my lord,
8 more.
8 more, so total 11.
And trial had was instituted against 8 plus 3, 11%.
Initially 3, my lord,
And then 8 plus 3, total 11.
11, my lord. So, my lord, the
And all these 11 persons are now represented.
my lord,
Saikia for 5 to 12. Saikia along with Madam Das and the other Mubarak for 2 to 4. Yes, did you find Mr. Mubarak? Yes.
So, Sarshi also fight only against 3 persons, my lord, first three.
Then 17-3, the 8 more were added.
My lord, 8 more.
Okay. Yes.
They are also subject to 302, my lord.
Hmm. Paragraph page 12, PW1.
My lord. PWD 1, my lord, this is the initially, my lord, that which has been deal about, my lord. Also, it has been about.
Then we'll
Evidence, my lord.
have all the evidence were taken again, all the evidence.
Again, my lord.
Then we'll go to the second part.
My lord, second part, my lord. This is our, after 6, my lord. After 6, my lord, we did deal about started, my lord. So not during 2006, my lord. So we have, my lord,
Initially, how many witnesses were taken?
11, my lord.
No, before the de novo.
My lord, before the dean of home, my lord. 7, my lord, okay. 1, 2, my lord, 6, my lord. 1 is my lord taken because Mr. S. Basho is a minor select. Those who my lord, he was not taken, my lord, that time. He was taken on 2004, 15, 6, 2004. So total 6, my lord, idea. Prior to dean of home.
De novo under what provisions of law?
They approved that one, it Honorable High Court by a petition that court directed for dean of home.
Where is that order?
My lord. My lord. I have found that, my lord.
And can you give us the reference of the order, date?
My lord, I'm sorry.
But these are not disputed, I think. Yes, Madam Begum. This aspect is not disputed. Then you come to the fresh evidence
My lord.
page
Page, my lord, that will be my lord, page 16,
16.
16, PW1. The complainant. That's 16. All the damage. Very good.
Yeah, the earlier evidence will not have any value over.
My lord, similar, my lord, nothing, my lord, same, my lord. Neither than the same thing.
Because if you see the provisions of 319,
My lord.
319 will be perhaps the provision.
minor, for minor, making them.
Now, this evidence of the witnesses will be taken again so far as the persons who were not initially made accused.
Accused minor.
But this evidence were already taken so far as the 3 number of accused were concerned.
Right.
So I think both the evidence, I think, will have to be read. I don't
But
know.
as per my knowledge goes, madam, actually they, if madam, they make them return accused person, they have given a chance, madam, whether you are rely on those evidence or not. If you have anything to say, you can go for procedure, they will call them. That is a
No, Mr.
procedure.
Sarani, you are absolutely correct. But their re-examination will only be restricted or confined to the purpose of the new accused persons,
Minor,
not for somebody for
minor,
whom they have already deposed.
minor,
It is not like 311.
minor.
311, the objective is entirely different.
Minor,
Power to summon material witness and examined person present. Even a re-examination. Now here, the fresh examination is only for the purpose that certain new persons have been added as accused. What do you have to say against them?
Right.
And give the new accused persons a chance of cross-examination.
Right.
So other earlier witness, I don't think it will be redundant. I
not
think
to be re-examined.
it cannot be redundant. I think
Until
it will still be
unless
relevant.
fall under.
For the first 3,
Minor,
that evidence would still be relevant.
minor.
But yes, but if it is a repetition,
Minor,
we can,
repetition minor.
then we can do.
Only that other accused person getting the scope of procedure.
Okay. Yes, 16.
Minor. I am the informant of this case. I know the accused person, including accused Hogendas, who is represented today by learned lawyers. On 8/3/2002, at about 7:30 p.m., I was not present in my house. I returned at about 7:30 p.m. My mother, Mongoli Das, and sister,
1 second. 1 second. Diagram. Where is it? Diagram. Diagram 12. Transport for ridiculous. Kind of poison ridiculous. In the translated copy,
minor.
that a kind of poison has been incorporated by, I don't know by what authority. It is not there. In the Azhar, it is not there. Azhar is only diachrome. Ati 11 বোঝাত মারপিট করে diachrome খুয়ায় মৃতপ্রায় অবস্থাত শহীদ স্মৃতির সংঘর বারান্দার পেলায় শুয়ে যায়. That part is not there. No, they should not have given in within bracket. It's not required. Not required and not desired also.
Minor.
Now, how can you impute any meaning? Unless the court directs. It may be poison, but you cannot say it's a poison. Because it has not been described as a poison by the informant.
Minor.
You cannot attribute meaning. Yes, please wait.
My mother,
Yes.
my mother, Mongoli Das and sister, Pratibha Das told me that my brother Pankaj was taken by Kondorpo, Manoj and Korup. Koilas, Gautam Das, Hogen Das, Rogen Sharma, Babul Das, Dipen Das, Ratul Sharma, and Amonendra Lohkar. They also threatened my mother and sister, stating that they will bring back Pankaj Das and no human rights should be met. They told that Pankaj Das will be taken to Sohit Smriti Sangha. I ran to the Sangha and saw that the doors and windows of the Sangha were closed and Pankaj was taken there. Hereafter, accused person opened the door and ran to the house of Pandharpur Das along with the accused Pandharpur Das, his wife Moni Bala Das and daughter Monica Das. Then I took Pankaj Das to our house and asked Pankaj Das about the occurrence. Pankaj told me that he should marry the daughter of Pandharpur Das since he could be killed. I thought that there might be danger to Pankaj, so I took Pankaj to the house of my elder brother Anindra Mohan Das as well. I kept Pankaj there and keeping Pankaj Das there, I returned home. At night at about 11:30 p.m. on that day, I heard sound of screaming. That is on 9. At night at about 11:30 p.m. on that day, I heard sound of screaming, I am dying. Hearing the sound, I rushed towards the Sohit Smriti Sangha. I lighted the torch, saw the accused person and recognized them. I saw a person lying on the ground. The accused person ran away and entered into the house of Pandharpur Das. I lighted the torch and saw Pankaj Das lying on the ground. I raised Halla. Villagers came. I asked Pankaj to how he came from Guwahati. Pankaj told me that he was taken from Guwahati by accused Manoj Das, Arup Das, Khagen Das, Jogesh Sharma, Dipen Das. Pankaj Das was in serious condition. Villagers advised me to shift Pankaj to the hospital immediately. I also saw one handkerchief and one bottle lying in the veranda of the Sangha. Pankaj told me that some poisonous fluid was poured in his eyes and mouth and he became blind. This is important matter. Then I took Pankaj to our home and then to Bourva Nursing Home at Nalbari. On 30/10/2002, Pankaj was referred to the International Hospital at Guwahati by Bourva Nursing Home. On the way to hospital, Pankaj died. The dead body of the Pankaj was taken to GMCH where postmortem was done. I lost Ezahar on that day at Ograpada PS. Exhibit 1 is the Ezahar filed by me and exhibit so on so. Cross-examination for a different next statement. Page 18. On oath cross-examination by defense. It is not a fact that I did not say before the IO that my mother and sister told me certain person, namely Pandharpur Das, Manoj Das, Arup Das, Kailash Das, Gautam Das, Khagen Das, Jogen Sharma, Babul Das, Dipen Das, Rakul Das, and Amoresh Lokar took away Pankaj Das. It is not a fact that I did not state before the IO that my mother and sister were cheating. I filed the Ezahar before Pankaj died. In the Ezahar, the name of the accused person who were later included were not given. On 8/2002, when I rushed to the Sohit Smriti Sangha, none accompanied me. I found that the doors and windows of the Sangha were closed. I heard that Pankaj was being threatened inside the house. When the door was opened, I entered into the room and found the accused person left the room. After my entering into the room, the accused person did not do anything to Pankaj. I took Pankaj to home and kept him in the night at my home. I did not file Ezahar to the police regarding the incident of 8/2002. It is not a fact that I did not say before the IO that Pankaj told me if he did not marry the daughter of Pandharpur, he could be killed and he could face consequences. On 9/2002, in the morning and about 6 a.m., I took Pankaj to Nulmati, Guwahati, and kept him there in the house of my elder brother, Anindra Mohan Das. On that day, my elder brother was at Jagirot, but my sister-in-law, Savita Das, was present in the house. I returned back in the evening.
I did not see any injury on the body of the Pankaj on 8/3/2002 and 9/3/2002. My elder brother or sister-in-law did not lose any case on 9/3/2002 and did not inform me anything about Pankaj. On 8/3/2002, when I went to the Shahid Smriti Sangha, I did not notice any other person except the accused person. In the night of 9/3/2002, I went to the Smriti Sangha, hearing Halla, and saw many persons in the veranda of Smriti Sangha. I saw accused person there assaulting Pankaj Das. It is not a fact that I depose falsely as to that accused person were assaulting Pankaj Das. It is not a fact that I did not state before the IO that I heard Pankaj to say, I am dying. I saw the accused person on 9/3/2002 from a distance about 150 feet. The night was dark. I lighted the torch. Accused person feet away, and I saw Pankaj lying on the veranda. When I told Pankaj, he told me that some poisonous article were put on his eyes and mouth, and he could not see. I personally did not see pouring of the poisonous articles. I found one bottle lying nearby, and cork of the bottle was open. A handkerchief was lying near Pankaj. I took the bottle and handkerchief on that night to my home. I handed over the bottle and handkerchief to the police. I have not seen the bottle and the handkerchief today in the court. I found smell on the face of Pankaj, but I could not recognize the smell. In the night of 9/3/2002, I took Pankaj to Borua Nursing Home, Nalbari, but doctors of the Borua Nursing Home referred Pankaj to International Hospital. Guwahati. Pankaj was in a position to speak quickly. When Pankaj was at Borua Nursing Home, but I did not know if medical officer of the Borua Nursing Home recorded any statement of Pankaj. Pankaj was taken to Guwahati by Nalbari Hazaru. After sending Pankaj, I went to close FIR. Pankaj expired on the way to Guwahati near Hazur. The Azhar submitted by me was written by one Kumar Das. It is not a fact that I did not mention in my Azhar that Pankaj was taken from Guwahati by accused Manoj Das, Varun Das, Fagen Das, Jagadish Sharma, and Dijan Das. Then says their names were not mentioned in the Azhar, but their names were stated before the IO from the International Hospital. From the International Hospital, the dead body of the Pankaj was sent for postmortem examination. Dead body of Pankaj was taken home on 10/3/2002 at about 8 p.m. and on the day his dead body was not cremated. When the dead body of Pankaj was received, I became unconscious. On the following morning, I gained senses. I heard that the dead body of the Pankaj was cremated in front of the Shiva Mandir of the accused Pandharpur Das. It is not a fact that the after cremation of the dead body of Pankaj, I, along with some other, damaged the house, vehicle extra of the accused person, and set fire. In the court of extension session, the Nalbari session case number was pending against me and other person. Because of my love, the dead body was my love in the accused person, therefore there is a case of my love, then this case is pending against me. Some of them my love. In our village, there is a road running from the east to west. On this road, at the western, the house of Pandharpur Das is situated. In front of the house of Pandharpur Das, the house of Harat Das is situated. In front of the house of Harat Das, there is a road from the north to south. In the east of the road, these are not relevant when I am meeting my love. Gorpla and peaceful. The Shahid Smriti Sangha is situated. In front of the Sangha, the house of Nirupama Das, CSB of PW2 my love, is situated. In the east of the Sangha, house of this Das is PW7 is situated.
In the east of the house of Deep Das, crossing houses of 5-6 families, my house is situated. On the west of the house of the Kandrapo Das and on the north of the Smriti Sangha, there is a big PDP. There is a bamboo grove on the backside of the house of Kumud Das. At that time, father of Kumud Das was at Guwahati. Police came to the evening of 10/3/2002. Police seized the bottle and the handkerchief from my home. It is not the fact that Pankaj had laughed with the money. It is not the fact that I lost the case falsely. It is not the fact that I did not see the offense. It is not the fact that out of the enmity we damaged the house of the accused person by fire. From that is evidence we can understand that at least they have brought the Pankaj to the Sohina on the 8th. Then he rescued him from there. Then next morning he brought his brother Nulmati. Then from Nulmati they have brought matter. This accused person, 5 accused person of the Nulmati they have brought. And on 9 at 11 PM madam. So there's a UNF guy, then gathering he came, but he had met his brother was lying in the courtyard of the Sangha madam. Then he said that madam, they have assaulted me and some poisonous thing has been made up on his face and mouth, madam. This is the madam in a nutshell, madam. So from here we can understand, madam, at least there is a happening. Incident was, madam, they are also not denying that.
No, we have read and read the position of PW1.
Madam,
Where is the statement that the deceased before his death has said that these accused persons have put this poison. Let us assume for a time being that it is poison.
Right.
That bottle. And we have also seen how the bottle was seized.
madam.
He says that if he had taken the bottle and the hanky with him,
Next day it was seen.
next day it was seized from his home. So that aspect is a very heavy burden upon him. But nonetheless, so far as the dying declaration is concerned,
Right.
where is the statement that the deceased had told him that it is the accused persons who have put this?
Madam, in a specific term, madam.
There is no statement.
Madam,
If you have missed
here by
anything,
page number 17, so
Yes.
Pankaj told me that some poisonous fluid was poured in the eyes and mouth and
he became blind. We have read this.
madam.
Pankaj, who has put this? That is more important for us. First, whether this is poison at all. That is one question.
Right.
Number two, it has been poured, but who has poured?
Madam, when he said that, but this person was present, among them, madam,
No.
specific.
It has to be specific.
Not
It's
specific.
a criminal trial.
Not specific.
He has not even named anybody. He has not even said they. He has not said anything.
Yes, madam. You know. Yes, madam. First email of the abort. Madam. Here, madam, page 13, madam, is earlier statement, madam.
Okay.
Made in 2024, madam.
Yes.
Before the beginning of trial, madam.
Hmm.
Thank you. Madam, may I read the page 13, madam?
Yes.
Reading from the madam. Madam, page number 13, possibly, madam, line.
Yes.
To my query, madam.
Hmm.
Left hand side, madam, to what? To my.
Yes.
Right hand side, madam.
Yes.
To my query, Pankaj has reported me that he was brought back from Guwahati by Manoj Das, Gaurav Das, Kailash Das, Yogesh Sharma, and took him to the house of the accused Chandrapada, where he was assaulted by the accused person, and thereafter took him to the Baranda of the SS Smriti Sangha. So it's Smriti Sangha. Further, he reported to us that the accused person poured some liquid substance in our eyes and mouth. We then shifted him to the sensor store. This is my lord, he said that, but even then not specifically.
No, but at least here he has said that the accused person.
My lord. Not the name has been, under my lord, the sixth person. Who brought him from the Guwahati.
Now see, now then another difference would come. Here in the first statement, though it may have relevance so far as the initial accused are concerned, he said that the accused person poured some liquid substance.
My lord.
Now, in the second statement at page 17,
Poisonous fluid.
Pankaj told me that some poisonous fluid
My lord. Developments.
development. What is 161? What did he say before the police? Okay, we'll come to the police statement. Okay, later on, okay. Then, yes, PW2.
Anyway, my lord, it is established that, my lord, they have brought, they have accepted, may not be medically, my lord, prove that there is an external injury, but they have brought, they have, so that much is coming, my lord. And something has been, my lord, in that case, that is also coming, my lord, whether it is poison or liquid substance or something, it is determined, my lord, to which statement. Next, my lord, those two will come to the PW2, my lord.
Yes,
That is the, my lord,
Nirupama,
second, my lord, second time, my lord.
25,
My Nirupama, my lord.
25.
She is the neighbor, my lord. Not neighbor, my lord, he is just nearby the place of offense, my lord. Just PW related that our resident is behind the, so it's British Tamil. I know the accused person. Three accused person are absent today. I know them too. I knew accused Pankaj Das Bhoga. I know informant Lavanya Das. He is interpreter of this Pankaj Das. I do not have any enmity or dispute with the accused person. Around 7:30 a.m. 8/2/2022, while I was coming from Guwahati, I saw the public had gathered at the village road. When I asked as to what had happened, I was told that the accused person had taken Bhoga, alias Pankaj, to Sahid Smriti Sangha. I went to the Sangha. I knocked at the door of the Sangha. Opening the door, I entered inside. I saw the accused person inside. I have seen accused Manoj and Orup in the court out of the accused person I had seen. So that means Manoj and Orup was present. The accused persons were threatening him that they would kill him. I offered assistance, whereupon Manoj Das pushed me out by the neck. Then I cried out, Pankaj is being assaulted. Then the people rushed there, whereupon the accused person entered the house of Manoj Das and Pandorko Das. Manoj Das threatened me and took Pankaj to his house. Here, sir. I left the home. I left for home. I came to know in the evening that Pankaj had been sent to Guwahati. Around 11 p.m. I heard, that is on the next day. Around 11 p.m. I heard sound, thump, thump. Then I heard someone uttering, Morilu, Morilu. Within bracket, I am dying, I am dying. We came out and passing the cross, I saw the accused person, Manoj Das, there. They were assaulting Pankaj. Pankaj asked to wash his mouth. Pankaj asked to wash his mouth. He also said something has been poured in my eyes. I saw a bottle with word, Dinocrom, the spelling is different, written on it and handkerchief lying there. When I asked Pankaj as to how he had come here from Guwahati, he replied me that Manoj, Orup, Ogen, Jogen, Sharma, defenders had brought him from the Guwahati. He also said that after beating him up in the house of Pandorko, they had brought him to the veranda of Sangha. When I sounded an alarm, a lot of people gathered there. Those people took Pankaj
to Nalbari for treatment. I did not go to Nalbari. Later, I came to know that he had been referred to Guwahati from Nalbari and that he had breathed his last on the way. Police examined me in connection with the incident. I stated before the police in the same manner I have stated today. Now the first part. So here, my lord, in the chief part, my lord, he admitted, my lord, that the deceased, my lord, discloses this name. He has been brought from Guwahati to death test, my lord, on 9th. Because he thought his younger brother complainant on in the morning, 9, the evening they have brought. Now close by defense. On 8/3/2002, I did not notice whether anybody else had gone to the Sangha prior to my going there. That day, after I had been pushed out of the Sangha by neck, I left the place, shouting I could learn from the couple of many villagers that Pankaj had been here, but I did not ask their names. It was Manoj who told me that my daughter had been abducted. It was Manoj who told me that my daughter had been abducted. I did not lose Azar with the police. It is, I don't think so it's related by maybe typographical mistake. It was Manoj who told me that my daughter had been abducted. I did not lose Azar with the police station. I stated to the police that I had been pushed out by neck. The accused person, namely Kondorpur Das, Udup Das, Monika Das, Kondorpur Das' wife Moina Das, Kailash Das, Gautam Das, Hogen Das, Yogesh Sharma, Dipen Das, and Babul Das, Amresh Lokar, and Rakul Sumar were present in the Smriti Sangha on 8/3/2022. I mentioned the names of those persons accused before the Daroga police officer. It is not a fact that I did not mention the name of those accused persons before the Daroga. The bottle and the handkerchief were lying near Pankaj. A VDP member took the bottle and handkerchief away. I did not notice whether the cap of the bottle was open or fixed to it. I first my toes on 11 p.m. 9 March after hearing a hue and cry. The accused persons were assaulting Pankaj. It is not a fact that I did not say this thing to police. I passed the torch from a close distance. I saw the accused person in the flash of the torch. I also shouted. Public came there. Smriti Sangha is situated in front of my house. A road runs east-west by the front of my house. Jungle are there behind the Sangha. It is not a fact that I stated to police that when I shouted that Pankaj was being assaulted, some boy entered the house of the conductor. My husband does not stay at home. Pramod Das is my son. At the time of incident, he was pursuing his higher secondary course. He did not go there along with me. I found Pankaj lying on the veranda of the Sangha. When the Pankaj asked to wash his face, other person, namely Gauri, Kumud, Rajiv, were present there. A lot of villagers were present there. Some Humid was there. I noticed injury on the person of Pankaj. I also saw blood oozing out from his person. I heard that Pankaj had laughed underscore daughter. I heard that on 8/2002, Pankaj was picked up from Sangha and was kept in the house of Lavanya. I saw that accused person running away. When I went there by passing the cross, I saw the accused person running away from a short distance. I did not know if it was noticed that Pankaj had a visiting camp with the family of the conductor. I am not aware if there had any discussion about the matter of marriage contract for daughter, Namita with Pankaj. I did not tell to police that after walking up, when I, along with my son Pranab, had gone to the Sangha, I had seen Pankaj lying and breathing on the veranda of the Sangha. It is not a fact that I stated to the police. It is not a fact that I stated to police that some boys had entered the house of Kondorpur. Kondorpur's wife had lodged a case against my husband and son, alleging them that they had burned their house. This case is pending. On 9th March, just after going to the Sangha, I did not meet Lavanya there.
police did not see the bottle and the handkerchief in my presence. I did not go to the medical college. Pankaj Das was brought on a vehicle. Neither my husband nor my son nor I came along with him. I did not see Pankaj being brought from Guwahati. I saw Pankaj being taken to Guwahati. A road run by the front of the house of Pandharpur. My house and the death of Devidas are located on the same boundary near Pittsburgh. The house of Devidas is in the east of Sangha. Lavana's house is 5 houses apart from the Sangha. It is not a fact that house of Pami and Bharat are situated in front of Pandharpur house. The house of Kumut Master is situated near the house of Pandharpur. I have heard that Pankaj was cremated in front of the temple of the house of the accused. I do not remember how many days after the incident I made statement to the police. I have not seen the bottle and the handkerchief in the food today. On 9th day of March, the people carried Pankaj to the house of Lavanya from the Sangha. It is not a fact that my husband and son have safeguarded the house and the since a case has been lost over the matter, I have adduced false evidence out of last night. And here also, madam, some of them, madam, she has supported minor, that there is a minor has been brought. He has seen accepting minor, taking him minor to the hospital, died minor.
See, since you have completed this PW2,
Minor.
we would have put this question later, we will still put, but three things immediately would like to. First, on 8-3 incident,
Minor.
first incident,
Minor.
8-3, as per PW1,
Minor.
page 16. Page 16.
Last day.
First paragraph on 8-3 at about 7:30 p.m.
Right.
Okay,
Minor.
and PW2 says 8-3, 7:30 a.m. Page 25. This is translated copy. Translated copy.
Minor.
So AM PM, if there is a typographical error,
Minor.
we may give you the benefit. But if it's not a typographical error, this is a major difference.
12 hour difference.
12 hours. Next, kindly come to she has made a page 26. She has made a direct statement. Page 26, third paragraph from the top.
Minor.
The second last line. He also said that is in direct first person. Something has been poured in my eyes.
Minor.
There is no statement regarding anything being put in his mouth to eat. Okay. She restricts to the pouring in the eye. Then kindly turn over the page. Page 27's last paragraph.
The bottle and
Bottle and handkerchief lying near Pankaj VDP member had taken the bottle. Lavanya says he had taken the bottle and the handkerchief with him and it was handed over to the police in the next morning. Because why this? I am pointing out because this will have a significance. If it is poison which you are trying to
protect
give
minor.
tracks upon,
Right.
that is poison. The poison was in a bottle. Handkerchief was also there. So how was it seized? Even if it was poison, the seizure has to be done in a manner prescribed because you are depending on the assertion or projection that it is poison.
Right.
So she says that it was taken by VDP. He says, Lavanya says that he had taken the same evening and given it back to the police on the next morning. And most important, page 28, this PW2, Nirupama says that she had noticed injury on the person of Pankaj. Page 28, third paragraph towards the last. I noticed injury on the person of Pankaj. I also saw blood oozing out from his person. This is something very serious. If blood was oozing out, There has to be blood stains somewhere there. There has to be, at least even if the blood stains are removed or maybe not preserved, and the aspect of injury on his body has to be there.
Poison, because of poison maybe come out with the.
No, then there has to be blood stains in
Right.
this place of, we have not reached the IO.
Right.
Maybe the IO has said something, we do
Right.
not know. But she has not said that the liquid from the bottle was administered to him. She has only said that liquid from the bottle was poured in his eyes. And that is the first person.
Right.
The deceased was telling him that they had put something in my eyes.
He has seen by own eyes.
Own eyes. No, not own eyes. The deceased first person has been, she has not seen. She has not seen, she has not said seeing. She only says, come to again, let us come there, page 20, 20, say 25, 26, 26. Page 26. They have not claimed about seeing this. He also said something has been poured in my eyes. She said that she saw them assaulting Pankaj. Pankaj asked us to wash his mouth. He also said something has been poured in my eyes.
This is person.
This is direct version.
Direct person.
First person,
PW.
PW2. Yes. Yes, next.
Up to 3 minutes.
Yes.
That is Gauri Das. Yes, but the accused person about 3 years ago offense took place on 9/6/2022 to 2002 at about 11:30 p.m. Occurrence took place in the veranda of Sohit City Sangha of Borkola. I was in my residence, which is situated about 40 feet away from the Sangha. The road was nearby. The road was near my house. On the day of occurrence at about 11:30 p.m., I was about to go to the bed. Then I heard cries, Morli. I found the voice of Pankaj Das. I come out from the house and went towards the Sangha. I had a 3 battery torchlight in my hand. In the light of the torch, I saw the accused person on the veranda of the Sangha and so Pankaj was lying in a very critical condition. I saw one bottle, 2B, containing poison, which smelled, and one handkerchief near Pankaj. Pankaj was crying Morilu. I asked him how he came from Guwahati to the place. Pankaj told me that the accused person came from Guwahati and assaulted him in the house of Pandharpur and brought him to the veranda of Sangha. Pankaj stated before me the name of the accused person, namely Pandharpur Das, Manoj Das, Urup Das, Kailash Das, Bhupen Das, Babul Das, to be the person who assaulted him. Pankaj told that accused person, with the help of handkerchief, they sprayed liquid on his face and eyes. But he's not saying poison, but something has been fired. Pankaj from the Sangha to their house and gave him first aid and then took him to Borwa Nursing Home at Nalbari. On 10/3/2002, as per advice of the doctor of Borwa Nursing Home, Pankaj was taken to International Hospital Guwahati. And on the way to Guwahati near Hazur, Pankaj succumbed to his injuries. Pankaj was taken to International Hospital Guwahati where he was declared dead. Police sent the dead body for postmortem examination to CMCH Guwahati. Monica, daughter of accused Pankaj, was wanted to marry Pankaj. Pankaj did not want to marry her. For that Pankaj was assaulted to cause his death.
So this is a 1 mile of resentment, why they have something. After the death of the Pankaj, there was a sensation in the locality when that body of Pankaj was taken to village. There was a gathering of hundreds of persons. I heard that the excited gathering set fire on the house of the Pandra. Accused person later on submitted one Ezahar to the police station against us, alleging that we set fire on the house. In the false case, I was also made accused. I stated before the IO. At the time of occurrence, there was darkness in the night. On 19/2002, I was in my home with my family member. I heard cries and I presumed the cries to be of Pankaj. Nirupama went with me to the place of occurrence. I saw the accused person in the veranda of Sangha. I did not call the accused person. It is not a fact that I did not state before the IO the names of the accused person, accused Pandarpo, Manoj, Uruk, Kailas, Gautam, Jogesh, Deepan, Amoresh Lokor, and Atul Sharma. The bottle which was found near Pankaj was its mouth open. I do not know about the taking of Pankaj to Guwahati on 8/3/2002. I do not know as to that Pankaj was committing. I do not know who took bottle and handkerchief. I have not seen the bottle and handkerchief break that day. I heard that there was a love affair of Pankaj with Monica. I do not remember if I stated to the IO that handkerchief and bottle were kept in the house of Ramesh Sharma. It is not a fact that I stated before the IO that Pankaj was vomiting and lying in the veranda of the Sangha in a critical condition. It is not a fact that I did not state before IO that Pankaj told me as to that he was taken from Guwahati and was assaulted in the house of Pandharpur. I did not see who brought Pankaj from Guwahati, and when I did not come to Nalbari with Pankaj to Borwa nursing home, I also did not go with Pankaj to Guwahati. It is not a fact that I did not state before the IO that after the death of the Pankaj, there was a sensation in the area and hundreds of people gathered. The dead body of Pankaj was cremated in front of the Mandir situated in the courtyard of the Pandharpur. I was not present at the time of cremation of the dead body of Pankaj. The gathering person set fire the house, car, and shop of Pandharpur. The house of Kailas, brother-in-law of Pandharpur, was also set on fire, which was near the house of Pandharpur. The house of Pandharpur is about 250 feet away from my house. I did not see fire on the house of Pandharpur and Kailas. I am also one of the accused in the case closing by Monica. I did not see any substance on the face of Pankaj. I did not see any substance on the face of the Pankaj. I also did not see any injury on the body of Pankaj. Borpala LP school is situated near the Sangha. The house of Bharat Das, situated on the west of the LP school. Pankaj was in his house on 9/3/2002, but he did not come to the Sangha in the night. Towards the east from my house, the house of Pankaj was situated. After crossing about 8 families on the west of my house, crossing the and one family of the family was situated. Accused defenders, Babul Das, Pandharpur Das, Guru Das, and Manoj Das are also from our village. House of defenders was adjacent to the Sangha. There was a big petty field backside of the Sangha. There was also some of bamboo grove in the west of the house of Nirupama. There was a bamboo grove. We took Pankaj from the Sangha to his home. We found Lavanya in the house of Pankaj. Lavanya is brought to Pankaj, one brother of the Lavanya named Kotin Das, living in Guwahati.
Pradeep was present on the.
Not
day.
present, not present. Not present.
Pradeep was not,
Not
my lordship, overtaken. The Pradeep was not present on the day of occurrence. I do not know if any FIR was lodged about missing of Pankaj from Guwahati. It is not a fact that I deposed falsely today. It is also not a fact that I did not see the accused person and I did not say their name before the I. Here, my lord. WC, my lord, at least he has, my lord, since that. And stating that there he, my lord, one of potential, my lord.
Mm.
Because why have they have made pick up? Because his daughter, accused number person is a Pankaj daughter as a Labek teacher, my lord. So they are forcing, my lord. He denied to my lord that he is a Labek or is not denying to many, my lord. Because of that, my lord, they pick up and assaulted, my lord. He supported that there is a, my lord, ground of, my lord, pick up this person and ground of assault, my lord, and bring the son of.
She did not see any substance on his face. She did not see any injury. Cross-examination
My
said
lord, that's it, my lord.
she takes
No substance, no injury.
a U-turn. Walked her face.
Other part, my lord, something, my lord.
Chief, she says I saw injury. Cross, no injury. 39, yes. Will 4. Foolish.
My lord. Let us. Know the government, he is my co-leader. I know all the accused persons, some of them are not present. I know them by their names and faces. Manoj Das, Urup Das, Gautam Das, and Amit Talgar are not present today. Hogen Das is also not present. I know this is Pankaj Das. The incident took place on 8 March and 9 March in the year 2002. At the time of the incident, I was coming from Borokola shop after doing shopping here. When I was coming, there was a hue and cry in switch number. I went there to see what had happened and saw the accused person there. There I also saw the accused persons who are not present today. I also saw disease compass there. The accused person were pro-beating. Pankaj, it should be a blow beating, maybe blow beating.
No, browbeating is there. Browbeating is the number.
Pankaj is forcing him to put signature. Meanwhile, Pankaj's elder brother Lavanya, accompanied by 2 other persons, arrived there and took Pankaj Das away from there. Thereafter, the accused person left the place by 3. I also left for my house then. My house is in front of Sambhav itself. In the morning on 9 March, in the next day, Pankaj Das, elder brother Lavanya took Pankaj to Guwahati. Around 6:30 a.m., while they were going by the front of our house, I saw them. On being asked, they replied me that they were going to Guwahati. Later, around 10:30, 11 p.m. that day itself, I heard a kick coming from the veranda of Pankaj. Then I was able. I got to hear that sound as I returned from a bit late after attending a village service. On hearing the sound, I went out to the road and heard the shriek of the person again. Then I assumed that the state sound had come from the field of the sun. Then I proceeded towards the direction. Then I saw the accused person present here. That prevented me from going ahead. As that prevented me, I raised an alarm. Hearing my alarm, the neighboring people arrived there. Whereupon the accused person hit the scene. Some 6-7 people of the locality arrived here. Neighboring people, namely Deep, Kumud, Gauri, Nirupama, Harmohan, and others arrived here. Later, a lot of people gathered here. After making an inquiry as to what had happened, we found Pankaj lying here. He was lying there in an injured state. We noticed a layer of some white substance in his eyes and face. Some white substance was found sticking on his face. Then we took Pankaj Das home. His condition was very critical. We took him to the nursing home owned by Nipen Malla Huzarburwa that very night and got him admitted there around 1 a.m. Since he did not recover a pulse, he was referred to International Hospital Guwahati, and accordingly, we took him to Guwahati at 10 a.m. on 10th March. While we were taking Pankaj to Guwahati, his condition deteriorated more. We reached International Hospital. Here, after examining Pankaj, the doctor declared him dead. Later, the police of the school PS were informed. Going there, the police examined the dead body and took it to Bhanagar for postmortem examination. Police prepared papers and helped in test. Police obtained my signature. Exhibit 3-1 is my signature. Exhibit 3. On being asked by the police, I stated the things that I have deposited. It was dark night at the time of the incident. I was at home. When I heard the scream. I was on the road when I heard the second scream. I reached an alarm from the field, not from the road. At that time, nobody was there with me. Therefore, I did not go to the veranda of the Sangha. As soon as I raised the alarm, other people came there. I did not see it as who had brought Pankaj to veranda of the Smriti Sangha that night. Later, when the public arrived there, the accused person did the scene. A road runs east-west through our village, and residences are there on both sides of the road. The residences of accused Kondorpo, Olu, Manoj, and Kagan are there in the west of the road. Bharat Das' house is at front accused Kondorpo Das. The house of witness Das' father is also situated here. It is not a fact that I did not step police there. Hearing the scream, I had gone there, and hearing the second scream, I had raised an alarm. I was questioned 3 days after the accident. It is not a fact that I stated to police. I could learn this morning that on 10/3/2002, that Pankaj Das became unconscious after consuming some medicine, and as soon as Pankaj reached Guwahati Hospital, he breathed his last. It is not a fact that I did not state to police that hearing the scream when I had gone to hospital, I had been resisted. Taking Pankaj along to Guwahati, Daboino left Pankaj in the house of his elder brother on Panindra. The accused person were in the Sangho on 8 March. Pankaj was there. No other person was there when the accused person were asking Pankaj to put his signature. On my arrival, I saw the accused person there. Going there, I could learn that since Pankaj had a love effort to accuse Kondorpo's daughter, Monica Das, a discussion was held here to get her marriage solemnized with him, and that for the purpose they wanted to obtain signature of Pankaj. Pankaj did not put his signature, but they were taking him to put his signature. I am also addressed as Babuti. Accused Kondorpo's wife, Monica Bala Das, closed a case against me, alleging that I had burned their house, property, vehicle, and shop. The number of said case is 144/04. 10 other persons and I were named as accused in that case, and the Honorable Assistant District Judge convicted my four accused persons in that case and sentenced them to 100 days imprisonment. Pankaj was breathing when we found Pankaj at the veranda. I did not touch the layer of white substance present on the face of Pankaj. Taking him to his house, we was thrown out with water. The house of Pankaj Das is 10 houses apart from the face of Pankaj agricultural field is there behind sorry Smriti Sangha. A first agricultural field is also there behind the house. There is no residence in that place. There is a bamboo grove west near the house of Nilkumadas, a road run by from Bhakti. Accused Amaresh Lohakar house is 4 kilometers away from our house. That is among the accused persons, 7 accused hail from our village. One came from Nalbari with Pankos on an ambassador card. I do not know to whom the ambassador belonged. When Pankos was taken to nursing home, he was not capable of speaking. It is not a fact that I did not state to the police that 8 March the accused person had taken Pankos to put his signature. It is not a fact that I have falsely stated that 8 see coming to the Sangha, Lavanya had taken Pankos away from there and the accused person who had taken Pankos to put his signature. It is not a fact that I did not state these things to police. While Pankos was being taken to Guwahati, I also went there with him, with them. Pankos died when he reached Dodora, Hajo. Public cremated the dead body of the Pankos in front of the Shiva Mandir secreted of the courtyard of the accused Kadapa. It is not a fact that I did not state to police that hearing the speak of the second time when I moved ahead, the accused person had resisted me. It is not a fact that since control force wife rose a case against me, I have produced false evidence against the accused person. They are also my lord. They have still been when they are my lord. But about the my lord, the poisonous things, my lord is not saying anything. But
No, let's see, here in page 41,
my lord,
same witness, page 41, the 4th paragraph. While we were taking Pankos to Guwahati, his condition deteriorated more. We reached International Hospital. There, after examining Pankos, the doctor declared him dead. Later, dispute clearance was informed and Bangar postmortem. Okay.
Right.
Then you kindly turn over the page at page 44. Last paragraph.
Dodora part, my lord.
Yes, police. I also went the same witness.
My lord.
Pankaj died when he reached Dodora.
Dodora part, my lord.
Then Dodora is in Hajo. From
In
Hajo
between.
to Guwahati, 30 kilometers.
In between, my lord.
No, from
Mumbai to Guwahati in between Dodora.
yes, from Dodora to Guwahati, another 30 kilometers.
My lord.
Is there any record of international hospital
Mumbai to
exhibited?
Guwahati, my lord. Okay.
No. Is there any record exhibited of any examination done in the international hospital?
No, my lord.
But the postmortem was done at GMCH.
Sure.
No, that is possible. That is possible.
But they have not done anything. That's they neither they have any third year in testing. Possibly he said that Dodora he died. In spite of that, they brought
Yes, that is possible. We are not saying.
he said not that doctor he can himself die. Then my lord, we come to next. Then my looks on the bus. But each interest number 4 is all along with the my lord district my lord. From beginning to Guwahati my lord. So from here. That's of the parents to Guwahati. Yes, 40 million. Much on the Dutch.
Again, this same witness 40, at page 43. PW4. Eighth and the 1, 2, 3, 4, 4 paragraphs. On 8th and 9th, I did not notice any external injury on the person of compulsion.
There is no explanation in that, but they are saying the SLP is there by the fact that there is no injury. 8 means the first day when they brought to the hospital for next day brought to Guwahati, after being to Guwahati, then the case not necessary. External injury from the
Because the whatever is your projection, the murderous assault was done on 9/3.
9.
Maybe by assault, maybe by poisoning, 9/3. 9/3 also, this witness number 4 says that he did not witness any external injury on the body of the deceased. We'll continue at 2 o'clock. But you try to finish. Because 3 o'clock we are 2:45 we have to rise. 3 o'clock there is a single bench. And there are how many? One more.
got some judgment, my lord, I need to go.
How many witnesses are there?
3 more.
3 more.
I close something.
Yes, that will not be possible. Yes, yes. This we are having doubt whether we'll be able to complete it or not. 2:45 we have to rise. 3 o'clock there is a single bench.
Some minor poisonous element is there, madam. Like from my.
What is it?
One is it is a dimicron and metformin are both oral medication used to manage type of 2 diabetes. They work through the different mechanism with metformin primarily decreasing glucose production in the liver and improving insulin sensitivity.
It is not poisonous. This is a medicine for diabetes.
But even if it takes if blood pressure decreases, may causes.
No. Not at all.
Not the immediate one.
It has got metformin. It increases the secretion of insulin. It is not poisonous at all.
And then action might have maybe spelling mistake may not be.
No, maybe there's a spelling mistake. Is there any other form by which something of this, which phonetically sounds like this?
Because I have not.
That is metformin is not poisonous.
The dichromate is this dichromate toxic in a rare and easily fatal event. The essential lethal dose of the toxin is 0.1. Dichromic acid is a hexavalent compound and the toxicity is attributed to its oxidizing effect.
Mr. Saranya, the proof of this bottle is by whom? Was bottle seized? Seized. Let us see the seizure list.
159.
इसके तरफ produced by Babonyodas.
One silver, one ghee colored towel like handkerchief. One silver colored empty plastic bottle containing poison, probably diacron. This is by whom? This is by the police. And it describes whatever has been said to the police by the witness. Where is the forensic? Was it sent for FSL? Then FSL there. Where? No, of the bottle, of the substance. That is in the Viceroy. We are not in the, we are on this. That is only the description given by some witness that
During
this
the
part-
course of Caesar.
the Caesar and during the course of recording the statement under 161. That this is dichotomy or whatever.
What? Right? Because, said when he started, something has been going in my mouth and eyes, and the latest to keep, and they have lost it. They have more water.
Now that we have seen, but we are also concerned, what is the ingredients of the elements found in the bottle?
Trichome or trichome.
We have already said that not only 1%.
That,
Something is poured in my.
that something has been poured, but what has been poured? It has to be corroborated with medical evidence.
They have washed them. What has not been done? And they postmortem lordship. And it postmortem also lordship, that is spinal cord and pain is also not examined. That is there in the postmortem.
Yes, we were at page 43 now, 45, I think. Yes, we'll go to
Kumudras, madam.
Kumud Chandra, page 49.
49.
Yes, please.
Earlier, I adduced evidence on in the court once. I know all accused who are either present or absent in the court. I knew this is Pankaj Das Poor. The incident took place on 9th March. Around 7 p.m. on 8th March, while I was coming home, I heard a commotion raised by some people in the street, which is on the arriving at home when I asked my wife as to what had happened there. She replied that the marriage between Pankaj and daughter of accused Kandarpo was going to be held in the Sangha. Then I went there. Going there, I saw the accused person were trying to solemnize the marriage forcibly, but we did not allow it to happen. Hereafter, we brought Pankaj home. The girl was also taken away by her parents. The accused person remained in the Sangha discussing something. In the morning on the following day, 9th March, Pankaj's elder brother Lavanya took him to Guwahati and left him in the house of his elder brother Panindra Mohan Das. In the morning, when I came across Lavanya and Pankaj on the way, I asked them as to where they are going, whereupon they told me that opposite thing. Around 8 p.m. that very day, one vehicle came and entered the house of Pandra. Thus, around 11 p.m., I heard a screaming coming from the veranda of the Sahih Smriti Sangha. Hearing the scream of Pankaj, I came out of the house taking a torch along and saw accused persons, namely Kandarpo, his son Arup, Manoj, Gautam, Kailas, Amrit, Khogin Das, Jogesh Sharma, Babul Das, Dipen Das, Rapul Sharma, and Amresh Rahapar cleaned the scene, leaving Pankaj at the veranda of the Sangha. Then a lot of other people, including Baputi, Pules, the Gauri Niru Das, Pradip Das, Bhuvan, and others also gathered here. When Pankaj was lying there, I asked him as to how he had reached this place. Whereupon he replied that Onu, Manoj, Jogesh, Dipen, and Babul Das had brought him there. We saw a bottle at the place where Pankaj was lying, a handkerchief, which was put in Pankaj's mouth, was also lying there. I have seen the same bottle and the handkerchief in the pool. I have seen the same bottle and handkerchief in the pool. Either two persons said not seen, but they have seen, madam.
Police seized those two articles and prepared a seizure list to that effect. Police took my signature in the seizure list. Exhibit 2 is the said seizure list and Exhibit 2 is my signature hearing. Material Exhibit 1 is the said handkerchief and Material Exhibit 2 is the said bottle. Conco said that something had been poured on his eyes and he could not see anything properly. Recognizing our voice, he replied to us. He told us that handkerchief and some obnoxious substance had been put in his mouth forcibly. We immediately took Conco's home from the veranda of the Sangha. Taking him home when we asked him about the incident, he replied in feeble voice that after bringing him from Guwahati, the accused person had assaulted him in the house of Conrad first, and thereafter taking him to the veranda of Sangha, they again assaulted him and poured some obnoxious substance on his eyes and mouth. We tended Conco's, providing messages, etc., and sent him to Nalbari in an ambassador car that very night. Then it was around 12:30 midnight. The following morning, the doctor referred Conco's to International Nursing Home, and accordingly, he was taken there. Thereafter, we went to Khobrapara police station and lodged an FIR, Ejahar. Lavanya Das lodged the said Ejahar. I wrote that Ejahar is part of person of the Lavanya, but he just paid total FIR. Exhibit 1 is the Ejahar, Exhibit 1 2 is my signature hearing as it's paid. Pankaj breathed his last on the way to Guwahati. Police took my statement. I have been working as a teacher for 27 years. I have mentioned in Ejahar the names of only 3 accused persons. I have not mentioned the names of the other accused persons. Deceased Pankaj was the son of my father's elder brother. On 8 March, going to the Sangha, I saw the accused person there. Pankaj was there too, except for Pankaj and the accused person. No other person was there inside the Sangha. Some other persons said that he had left affairs with Conrad's daughter Monica, but I am not aware of it, nor I who believe it. Going to the Sangha, we brought Pankaj along therefrom. The family members of Lavanya did not give their consent to the marriage, which was supposed to be solemnized between Conrad's daughter and Pankaj. I also did not give consent to that marriage. Pankaj was at his house on 8 March. Lavanya who resides in that house. In the early morning of 9th March, Lavanya left for Guwahati, taking Pankaj alone. One Horendas also accompanied them. I heard that Lavanya and Horen had taken Pankaj along to the house of his elder brother Anindra Das and left him there. I went to school on 9th March. I did not see who came in the vehicle that entered the house of the accused Conrad in the evening. I did not see it is as to how Pankaj had come to the Borkhola village that day. I did not also see it as to how Pankaj had come to the veranda of the Sangha. On 8th and 9th day of month, I did not see any injury on the body of Pankaj. I do not know what rubbed on the eyes of Pankaj, but I noticed a drastic change on his face. He was lying prostrated on the veranda of Sangha. Material Exhibit 2 is the bottle was lying there. I do not know what the bottle contained. The handkerchief was lying near Pankaj. Omit's was also there. I do not know who took the bottle and Material Exhibit 1, the handkerchief from the place. I do not know who handed over the Material Exhibit 1 and Material Exhibit 2 to police at the time of seizure of those articles. But someone among us handed over those articles to the police. I asked nothing to Pankaj on 8 March. On 9th day of March, Pankaj was capable of speaking in feeble voice. It is not a fact that I did not tell the police that Pankaj was
capable of speaking in people's. I stated that, but I do not know what police had written. It is a fact that I did not state to police that Pankaj had mentioned the names of the accused person in people ways. Police went to the veranda of the Sangha. The Sangha is situated 3 houses apart from our house. Here, 3 residents are there in between the Sangha and my house. There is an LP school near the Sangha. A big big field is there in front of the said school, and accused Kandarpo Sharma house is in the west of the field and in the south of the road. Accused Babul Das house is to east of our house. On 9th March, I did not meet the accused person during daytime. It was a dark night on 9th March. I stated to the police that hearing the scream of Pankaj at the state Sangha at 11 p.m. on 9/2002, I, accompanied by other villagers, had gone there and had seen Pankaj lying on the veranda of Sahit Smriti Sangha in Morben state, and that vomit and other substances were coming out from his mouth. It is not a fact that I, as deposed today, did not tell the name of any accused person to the police. That I did not also state them that the Pankaj had told the names of the accused person in people ways. At the time of lodging at the hall, we were not aware of the fact that Pankaj had died. Public cremated the dead body of Pankaj in front of the Shiva Mandir situated at the courtyard of the accused Kandarpo. I did not go there. I was not present. I was convicted in the case brought by Kandarpo's wife, Moina, on the allegation of setting their house vehicle shop extra on fire, and I was awarded punishment in connection with the case. Assistant Session Judge disposed the state case of by passing a judgment. When Pankaj uttered the name of the accused person in people ways, other people, including Baputi and we, were also there along with me. It is not a fact that I did not state the fact police. I informed nothing to police regarding incident that happened on 8 March. Earlier, I adduced evidence in this court once in 2004. Pankaj elder brother Maninder did not lose any case with Numati police station. I have adduced false evidence today out of the grass that I have harbored because of the case lost by the counterpart by Mohandas. And for that sake of my brother, he has seen and he the witness by seeing the exhibit mind. But he does not say that from whom it is seized, but he's a seizure witness, the material exhibit 1 and 2.
Those have been proved as material exhibits.
One.
The bottle
One is
and
the bottle and handcuff.
and he was examined on 30/3/2007.
My God. 30 March 30. Here, my lord. Then my lord 5 again, it should have been 6 5. 6 is missing in it's 5 again.
No, this is not 5. The 5 is as with the. This is for the earlier.
My lord. But this earlier 5, my lord. Scientific officer, my lord.
No, scientific officer has. Scientific officer is PW8 at page 60.
He has done postmortem, my lord.
Postmortem.
Dr. Toru Kumar does
Okay.
postmortem.
Also, PW5 is there. Okay.
On 15/3/2002, I worked as a scientific officer at SL Guwahati, Assam. On that day, I received a parcel from Director FSL, which was sent by CGM Guwahati in connection with school PD. PSUD norm 17(2). On opening the parcel, I found 7 extra
Exhibits.
exhibits into different containers. And the exhibits were marked by me as follows. 1 plastic jar containing stomach
With content.
with its content, portion of small intestine with the contents, portion of liver with gallbladder, 1 kidney, portion of lung, and portion of brain, and the exhibits were marked by me as exhibit so and so so. So 1 glass bottle, 1 glass bottle containing sample of preservative, saturated solution of common salt marked by me as exhibit 134. I carefully examined the above exhibits and following the result of my examination. Result of examination on exhibit norms 134, 134B, C, D, E, F gave negative test of common poison. Exhibit 3 is my report, exhibit 3 is my claim. So this has been scientifically minor analysis or examining minor, but it found that common, there is no test of gave negative test of common poison minor. Then my 7 is one of the this way. Case 58 minor.
There is no 6. PW6.
Minor is 6 is minor, not there minor. 6 is ideal minor, ideal time minor. It was Pulen Chandra Das. He has been examined as 4 in the minor second minor examination. So the 6 is missing minor. I think there is 2 5, probably one should have been 6 minor. All 5 1 will 5. So 6 is missing, the 7 minor. Here it is 7. Is it deep Chandra Das? I know that.
Yeah,
it was
just a
for-
minute. Just a minute. Actually, Kumud was going on serially. Because Kumud in the earlier round, he was examined as PW3 at page 45.
Minor.
This is Kumud.
Minor.
After the remand, he reposes as PW5. It is at page 49.
Minor.
After page 49 comes PW. Okay, it should have been 6 probably. Because in the earlier occasion, this scientific officer was PW5.
Minor.
It should be, I think, 6. Because he was not re-examined.
Minor. Scientific officer.
He being an official witness,
Otherwise, no.
there was no reason.
There are 2 types, 5 is 2 types. Earlier 5, and second type 5 by Kumud Chandra Das. Was examined 33 to 37.
Okay, then after Kumud,
Minor is 7, page 50.
Deep Chandra Rekha.
Minor.
Who is he?
I know the accused person. I knew the Pankaj. This is on 9/2002 at about 11 p.m. I was in my house and went to the bed for sleep. I heard halla from outside. I came out from my house to the road with a torch and saw Kandarpur Das, Manoj Das, Arun Das, Das, Gautam Das, Yogesh Das, Amrital Das, Ratul Kumar in the
Varanda.
veranda of Switi Sangha. They asked me not to go there. About 4 or 5 days ago, Manoj Das began us about the occurrence of an incident in the village. I found Pankaj is seriously injured condition in the veranda of the Sangha. And Pankaj told me that Manoj and Adar
Assaulted him.
assaulted him. Thereafter, the villagers went there and we took Pankaj, his house. We took Pankaj to Nalbari Goa Nursing Home. From Nalbari, he was referred to Nursing Home Guwahati. On the way, Pankaj died. The dead body of the Pankaj was sent to the GMC and postmortem examination was performed. So, the villagers cremated the dead body of the Pankaj in the courtyard of the Kandarpur Das. I was not present at the time of cremation. At time cremation, the villagers burned the house of Kandarpur and I was an accused in the case. Those by burning the house of Kandarpur. My statement was recorded by police. It is not a fact that I did not state before IO. I stated today in the court. It is not a fact that I did not state before IO the name of the Kailash, Manoj, and others. The villagers found a bottle of poison at the place of occurrence. When I went to the place of occurrence, there was no other person except accused person. When I reached Halla, villagers came. Hearing my voice, villagers one went to the place of occurrence. The deceased is my co-villager. It is not a fact that I did not state before IO that I found the accused person at the place of occurrence. My mother normally did not go to the place of occurrence, but hearing Halla, she came outside. I did not accompany Pankaj to Nalbari Hospital. I saw some vomit near Pankaj at the place of occurrence. When I myself and villager reached the place of occurrence, thereafter no occurrence took place. So here also that he has seen the Pankaj was lying and he has been assaulted by these people.
The significant part of his PW7
Right.
is that the deceased told him
Right.
that the accused persons had assaulted him.
Right.
He has said on page 58. Pankaj told, the second paragraph, Pankaj
Right.
told me that Manoj and others assaulted him.
Right. My doctor said that I will. Where is the doctor's note? On 10/2002, I was medical officer of duty in the also got it.
Yes, sir.
In the Department of Forensic Medicine, Guwahati Medical College, Guwahati. On that day, I conducted postmortem examination on the body of Pankaj aged about 20 years. Son of late Harisharan Das of village Varsala, PS, Bhagrapara district, Nalbari, who was initially admitted in the International Hospital. The dead body was escorted and identified by Constable Dhananjay Honoram Bashya and Panindra Mohan Das, elder brother of the deceased in connection with the dispute case now 17/2002. Police sent the dead body by preparing a salan which I received and sent to the receipt copy to the police with my signature on the salan. Exhibit 4 is the salan. 4(1) is my signature and accordingly I have performed the postmortem examination and found as follows. On examination, one male dead body, average in dark brown complexion, dressed in one white gamusa, one stiff full shirt, one genji covered by one red blanket, eyes closed, mouth closed, one red chip present around the right wrist ring, body cold intact, rigor mortis present all over the body, Anna Spanish, scorpium healthy, injury, not found, skull, and vertebrae healthy, membranes congested, brain congested, spinal cord not examined, that spinal cord not examined, liver congested, spleen healthy, kidney congested, bladder healthy and empty. Pleura congested, both lungs congested, stomach wall healthy, mucosa congested, petty hemorrhage present of mucosa at place. Stomach contains 75 grams of brown liquid. Hysteria reserved for chemical analysis as under.
Yes, jar 1 and
Jar one,
jar
stomach
2. Yes,
contain-
we have read this.
Minor,
Jar 1 and jar 2.
minor. Therefore, bicarbonate is saturated solution of sodium. Opinion. The opinion regarding the cause of death was kept pending till receipt of the report of chemical analysis of viscera. Exit 5 the PM. So, matter that report has been sent, that there is no matter general negative of test general for you. After the more exception, matter that has been. That's
And in the cross examination, he said that usually occurs in case of natural death.
necessary. Basically, I think that therefore my other person will be examining his placement.
PW9.
PW9. Ten 2002, I was OCR Yes, on that day, I received one FR exhibit on loss by Labunda Das. On receipt of the same, I registered a case bearing Bhograpura PS so exhibit 1 is the FR exhibit 3 is my signature with my registration mark. I entrusted SI Sushil Kumar Talukdar to investigate the case. Subsequently, for better investigation, I asked Sri S.K. Talukdar to hand over the case directly to me. And accordingly, he handed over the case directly to me. SI Sushil Kumar Talukdar recorded a statement of the witnesses and he visited the place of occurrence and prepared the statement of the place of occurrence. Postmortem of the deceased was performed at GMC at Guwahati and I collected the SCD. At the conclusion of the investigation, I submitted charges against the accused person, namely Kondorpo Das, Korup Das, Manoj Das, under section 302, /54 IPC. Exhibit 6 is the trustee. Exhibit 6.1 my signature, SI Sushil Kumar Talukdar, who initially investigated the case, already expired. SI SK Talukdar during investigation seized one towel, light handkerchief of blue color, tea color. One plastic bottle suspected to be contain poison. Dimocom produced before SI SK Talukdar by Lavanya Das. Exhibit 2 is the same signature. Exhibit 2 is the signature of SK Talukdar, which I know. From the report, it reveals that the stomach, with its contents portion of the small intestine, with its content portion of liver, with gallbladder, kidney portion of lung, and portion of brain were sent to FSL for examination. And I found the report of SFL when I submitted charge of the case. Exhibit 7 the sketchman, Exhibit 7.1 the signature of SI SK Talukdar, which I know. I am well conversant with handwriting and the signature of SI SK Talukdar since he working with me in the same station for about 2 years. Now proceed. I received the SIR on at the PS on 10/3/2000. Yes, 2002 at 2:30 PM. These articles are not available before the court today. Inquest was not done by me. Dead body was not sent by me for the postmortem examination. I did not send the viscera of the dead body for FSL examination. PW over Lavanya Das did not stated before the IO that Koilas Das, Gautam Das, Hogan Das, Yogesh Das, Babul Das, Upen Das, Rahul Das, and Amresh Thapar took away Pankaj Das. PW one Lavanya did not state before the IO that his mother and sister were taken by the accused person. PW1 did not state before the IO that Pankaj told him that he would be killed if he, Pankaj, would not marry the daughter of the Khandarpo. Monica is the daughter of Khandarpo and sister of accused Manoj. This witness, PW1, did not state before the IO that he heard sound and time. Date of occurrence on 10/3.
But there is a contradiction.
Contradiction of only PW1. Only in case of PW1.
No, this,
In my report that he did not state that those others name who have been subsequently implicated. Those names are there.
he sound, regarding the sound, I am dying also.
Then threatening part also my lord. Death of Caesar on 10/3/2002, statement of witness Nirupama Das, PW2, was recorded by IO on 30/10/3/2. PW2 Nirupama Das did not state before IO to have seen accused person asserting that this is Pankaj Das. That is one contradiction. Then PW4 Gauri Das did not mention before IO the name of the accused Kailas, Gautam, Yogesh, Amresh Thapar, Laskar, but he stated before IO the names of the Manoj, Poro, and Khandarpo Das and others. PW3 did not state before the IO that Pankaj told him that the accused person took him from Guwahati and assaulted him in the house of Khandarpo. It is not a fact that I did not investigate the case properly. That must only be. So, in case of PW1 minor, if C is minor, they have minor being try to bring that contradiction, and in case of 2, 1 contradiction, in case of 1 contradiction. And in case of 3, bringing from Guwahati, that focus is that will be police. Actually, there's some minus 10 minus what they have stated. 10 in the minor, not 11 minor.
He done the inquest.
Minor, not 11 yet. So minor, we will go to the minor lead postmortem report minor. There is some left in the part of the minor where they have to minor incoming those part also minor. And 170.
Chapter 178.
70 the postmortem manner. External appearance primary manner.
Yes.
Page 179, external appearance, condition of the subject stout, emaciated, decomposed, etc. One male dead body of average build, dark brown complexion. Dressed in one with gamusa. Dressed in one with gamusa. One stiff full shirt, one genji covered by one red blanket, eyes closed.
Now, this you have already read.
My lord.
And injury not found, injury not
Brain
found,
and spinal cord, madam, they have not,
not examined,
Examined the
and
minor-
injury is not found.
madam. Then,
External
madam, in
report.
the right lung, madam, both lungs are congested on section on the liquid that comes out. So the last minor, why did it come out? The normal, might be there may internal injury, madam. That's not reflect internal or outer injury, madam.
No any disease or injury seen. Just after that.
Madam. But there must be some reason, madam, that to reflect that and check why did
That- And that is why, again, at muscles, bone, joints, no injury not found, page 181.
then madam,
Viscera preserved for chemical analysis. The chemical analysis done, viscera report has come, PW 6, 5 or 6, whatever. Yes,
that trial court, madam, that minor. The dying declaration, madam. Of accepting, madam, because dying declaration, madam, he has state of mind, madam, it's a last. So to say, when people die, madam, never see, madam, false. Automatically comes out truth, madam, as he has said, madam. Before the Q1, 2, 3 and the 5, 7 cases, madam. They have assaulted me, they have put this something in my face, madam. And the other one, they will say that it is not worst, madam. That are. Maybe that affect madam. That- Because poison madam, sometimes we allow one with not very poison madam. But it affects in the stomach, madam. Sometimes internal injury madam cause that madam. Just for the outer injury madam. Or external injury madam. So madam, until unless madam, the madam, there is a specific development from the PWS madam. That is, after that, he has been assaulted by his accused person, basically 1, 2, 3 and 4 madam, father and 2 sons. In the FIR also their names appears. So they assaulted him and poured this madam, liquid madam, the poisonous in the mouth, in the eyes madam, by the plastic madam. And those has been said, why is madam, there is some madam, decimated in Caesar madam. Because Caesar madam, he from the place of occurrence, the PW said that I too. Then handed over to police seized from him, and somebody has in history of that some madam, even then the Caesar is there. Maybe Christopher could home. And there is no madam from the defense side, madam. If not demolished, that there is not at all Caesar, not from anybody. Those kind of madam, the anchor seat and the bottom never sees madam. That is not coming, my lord. Establish that there is a Caesar. Only thing that this sees bottom, the liquid, whether it is a poison or not, madam. Suppose, madam, it is not poison. What is the madam effect of his death, madam? Why he has died, madam? Here must be because everything has established. He has been robbed, he has been assaulted, he has been confined in the club. The scene also. Only thing is that here is no external injury as per the medical report. But here also we just said that there is an injury. And some say that they have seen the assault, they have not seen the injury made. So the injury matter is an internal injury because of assault without damaging the minor. Or causing bruise and minor anything minor. So that affects minor due to that he died twice. So it is a minor said to be described that as part of because ocular evidence is different from the minor doctor's opinion minor. So if minor ocular evidence minor my lord, believable, then my lord, the doctor's evidence is discarded, my lord. So my lord, I think there is a my lord, the prosecution, my lord, prove that there is a substance in the my lord, statement of the PW's my lord, that there is a assault due to assault on due to administering poison. He died. My lord. Now, in this regard, my lord, I came in the middle of the case, my lord. There were my lord, written argument, my lord.
Where?
Elect with the my lord, appeal, my lord. May I refer also self, I have done it out, my lord. That I am relying, my lord. Because of medical part, my lord, here, my lord. My friend has nicely, my lord, explained here, my lord.
Yes, yes, same thing. Written argument. Yes, we've seen. We have found written argument.
I'm relying, my lord, that argument, my lord. Well, apart from government, my lord.
Let me read it. Extra copy.
Thank you.
Today it may not be possible.
My lord, my lord.
Tomorrow we'll finish.
My lord, maybe not, a little bit more, my lord. Tomorrow I have three methods for hearing, my lord.
This you have to complete. This you have to give. How it will not take more than 10 minutes, I think.
My lord.
How long will you take?
My lord, I just said that.
Then cite it today. That you complete your part today.
My lord.
This matter you cannot afford to leave like this. Yes. Yes, please.
My lord. First we come to the matter, then Lakshman matter, 2006 SSC, paragraph 3.
Which one?
Regarding matter, dying declaration matter.
Lakshman, which paragraph?
My lord, I've given a note, my lord, not my lord. Yes, specifically. Regarding my lord, a man is a deathbed is very solemnly and saying it is legal in the law to accept the veracity of a dying declaration can be
Veracity of station, veracity of statement.
Right. So, my lord, whether that's the type of mistake. May I read my paragraph 3, my lord?
Yes. No, not required. You can just refer. These are your case
My-
laws.
My lord. Only to refer, I have specific stated my lord. Paragraph is on my lord. Only I have to read it out. The second is my lord regarding High Court has a full power to review my lord in appeal also. Reappraise the evidence, my lord. My lord, the law is that if the court is satisfied that dying declaration is true and the made voluntarily by the deceased, conviction can be based only on it without any further corroboration, if it is believable, my lord. Court, my lord, dying declaration can be a sole basis of conviction if it is trustworthy, voluntary, blameless, and reliable. Then, my lord. Then, fifth, my lord, it is neither a rule of law nor a prudence that a dying declaration requires to be corroborated by other evidence before a conviction can be based.
Hmm.
Then my lord, 6, this is regarding my lord, dying declaration and fullness my lord. 7, my lord, and the
Expert
expert opinion my lord, how can be my lord, if it is my lord, evidence believable. There's other my lord to the principle of my lord. This is last item my lord. 8, my lord, the various principles laid down by the pronouncement of the court in the suit dying declaration my lord. Series of my lord cases we discussed my lord, how much that is the color of my lord, one critical. That's my my lord.
And 8 principles, okay.
My principle matter. This paragraph
Manjunath.
11.2, 11.11.
Okay. Yes, tomorrow, first item is hearing. We'll complete tomorrow.
Right.
Your presence may not be necessary, you
My-
can have your colleague.
My lord.
Third. 3. M. Saranya, Leonard Counsel for the appellant, who has concluded his arguments, is for further hearing tomorrow as part of.
Item number 6, there are certain development. The case relates to promotion and my email was thrown to another point. And one of the reason was that departmental proceeding was pending. And subsequently, I was exonerated from all the charges to bring it on record. So my time.
21 matter, why should we grant you time?
So,
When did you retire?
I also retired from provision,
When?
31st of March 2023.
23.
Yes.
You have not cared to file any affidavit, why should you grant time? Sorry. Yes, next.
So the declaration item 3 methods the petitioner established not to raise that I have to do. So already got the job.
Your NFD,
Yes.
NFD Learned Counsel for the petitioner submits that he has instructions not to press this petition. Any government advocate? No government advocate. But has to be there. No government advocate is there. All the matters, GSM is a party. Non-appeals for the state respondent. Pero. However, pero, considering the efforts that prayer, petition is dismissed as not pressed. Yes.
Item 1. The petitioner is the wife of this is government servant. What happened with the direction for recovery? But in fact, the recovery was made.
Yes, we record your name, earlier case. When dismissed as not pressed. Somebody will, can ask you, review somebody, if you are not able to come. We don't want to record your absence in an order. You have so many numbers of one advocate, not to put you, non-available, no problem. So do not learn a senior advocate is present. Yes, what is this?
It's like the recovery was paid from the this is husband's petition of the petitioner. 6,75,000 an hour. What happened? There was a disciplinary proceeding against him after his retirement. The records were produced, and it was time was sought because they wanted to verify whether government sanction was taken because it was initiated after retirement. That's where how the matter was spoiled. It came a long time back. That's what it was not listed.
Mr. H. Sharma was appearing then, my lord, in this case.
Kindly give some accommodation, I'll say that.
Still matter, Mr. Nath, very embarrassing for this court. We have, especially we have listed this matter, we are, as you know, we are in a special DB. Till then, we have said that list all matters. On Friday. On Friday. Third, we am Dr. Leonard Counsel for the petitioner. Also heard Sri Srinath Leonard Senior Advocate Sam, as well as Sri S.K. Mehdi, Leonard Standing Counsel AG. Accountant General, Para. The matter was adjourned on earlier instance. The, it also appears that the Venice State Council was to obtain instructions with regard to the aspect of compliance of Rule 21 of the Assam Services Within Bracket Pension Bracket Close Rules 1969. Para. Now the London State Council has prayed for some time, some more time, Para. As the matter is of the year 2016. A short accommodation is granted, directing listing of this matter on Friday. Friday, you have the instructions, otherwise we'll assume that there is no sanction. Item 2. Yes, Mr. Mahato.
Actually, the external repetition which is pending similar matter, similar subject matter is already pending before the division.
Regarding what?
Regarding the appointment of railroad employees. Actually, the main reason there has been mentioned is the
Writ appeal has been preferred by whom?
by
The state?
no, not the advocate itself.
No, by the petitioner or by the state?
By the petition.
Their writ petition were dismissed.
Yes, sir. This and the order is. Gentleman order.
Yes, what do you say, Mr. Manto?
Otherwise, lordship, the whole matter, including my matter, all was typed, lordship. But during the course of hearing, lordship, during the case of the hearing, it has been found that my matter was silently declined. So, lordship, by order dated 23/6/23, the department was asked to file affidavit. But in my petition, lordship, though I was terminated, before termination, I have come to this court that my appointment was genuine and my remaining salary should be given. They have no response given, and therefore the lordship allowed page number 23.
Now, where is that observation of this court that your matter is different? Which order?
There is no order, but during the course of the lordship.
Which hearing?
That judgment. All the matter was state lordship. I was protest state lordship. At the time of hearing lordship, I pointed out before the lordship that my matter was slightly defined on the stand of page number 22. Can you see page number?
Does it say of the judgment?
Yes, yes. 23 of the my petition in there is another judgment in favor of mine.
No, page number 23.
23.
No, not 23. There are cost titles to page number 51.
Page number 27 in my
Of your repetition.
11 paragraph in my
27. That is, it starts from the page number 23, original judgment.
Yes, yes. 27. Yes. Which paragraph?
Lordship, paragraph number 6.
Yes.
The Learned Counsel appearing for the respondent sought for time to take instruction.
Hmm.
However, I am not inclined to give any more time since they have been given sufficient opportunity to either obtain instruction or file affidavit, if to advise. It has been sufficiently shown by the authorities concerned that the petitioner appointment was genuine. However, it appears that the screening committee constituted for the purpose is yet to come out with their findings. But the fact that the petitioner has been working for so long and have been certified by competent officer as generally appointed, prima facie showed that her case is most likely to be found genuine by the screening committee. In these days of high inflation, it is difficult to imagine how a government servant who transit her or day-to-day life without pay for so salary months. It is true that the government must go into the fact finding, but they must also not lose sight to the suffering the petitioner has been going through. The inquiry concerned cannot and should not linger on for a long time. Therefore, keeping in with this immediate need.
Read the salary. Yes.
Then Lordship, my salary, then after this judgment, then they release my 3 lakhs of salary, the pending salary.
Okay, thereafter.
Thereafter, Lordship, the termination letter has been given to me. Then Lordship, with the other candidate, Lordship, I have also filed Lordship. Whatever Lordship, there are the two lot of petitions in the judgment. One set of petitions was allowed because there was advertisement. In one set of judgment was dismissed because there was not advertisement. And my case probably in my case also there is no judgment, no advertisement.
Where is this order of 17/10/2019? Your termination is 21/10.
21 and
It has been done as per 17/10/19.
17/10.
Where is 17/10?
17/10 that has been not shown. Therefore,
Where is 17/10?
there is an inquiry report.
But as regards the any previous orders, no such direction was given on this issue. That's why
I can wait, Lordship, but that is that.
No, Mr. Mamta, you are not correct in contending that your matter, so far as the termination is concerned, has to be treated separately. It was treated separately so far as salaries part was concerned. Therefore, order was passed to pay your salary, which has been done. Thereafter, you have been terminated from service, which is a fresh cause of action.
That's all. I have challenged.
Now, this kind of fresh causes of action are also the subject matter of various petitions which has reached the division bench.
Yes.
Now they is pending before the division
Pending
bench.
Yes, sir. But so I can wait, Lordship, but
Heard Sri D. Mahanta Learned Counsel for the petition as a registry. And we Learned Counsel appearing on instruction of Sri B. Gogoi, Standing Counsel, Health and Family Welfare Department. Sarah? Sri Mia has submitted that similar causes of action which were espoused have been rejected by this court in various petitions, including WPC 5013 of 2020, wide judgment and order dated 29/9/2023. And the said judgment is the subject matter of challenge in WA number 429 of 2023, which is pending. In view of the aforesaid, in view of the aforesaid facts and the aforesaid fact has not been disputed by the Learned Counsel for the petitioner. In view of the aforesaid development, consideration of this writ petition is deferred till the outcome of WA 429 of 2023. This after 2 months, on which date development, if any, in the aforesaid writ appeal may be apprised. You take this back.
Item 4.
When was the affidavit filed? We filed it within 2 weeks. The filed in January 2024, we are in May. If you have not filed for last 3 months, we cannot help.
No, more than 2 months. Runway is not 24 months.
24. Why should it run time?
They were filed by 2 weeks now, so that it can be.
What is your name? HJB. Ms. HJB Learned Counsel appearing on instruction of Sri J.I. Borbia, Learned Counsel for the petitioner, has paid for some time to file rejoinder affidavit. Full stop. It have Sri Goswami, Learned Counsel, and Learned CDC has however informed that the affidavit in opposition was filed way back on 29/1/2024. Full stop. Para. In that view of the matter, this court has reluctantly granted 10 days time, 10 days further time to file the affidavit in rejoinder. Rejoinder affidavit. List after 10 days, para list after 10 days.
Item 5.
Yes. And 7/6/93 appointed as rifleman, Assam Rifle.
He completed the commando course, phase 17, in 1998.
Yes.
But in 2000, and exact to phase 19, he has also completed the training course.
Yes.
After almost 10 years of his service, petitioner was on leave member, he was a full member. After his melod leave is completed, he is ready to come to his post melod. This towards further. Then in the first attempt, his grandfather became in melod, he was admitted to hospital. And finally he was died melod. For the second melod, he prayed for extension of the melod.
Yes.
He came there melod. But they will be in the process, my lord, coming, doing and utilization and died, my lord. There is, my lord, delay of 10 days of his service. For that reason, my lord, petitioner was not given any opportunity, no hearing. Nothing, my lord, he was given 28 days rigorous imprisonment. And my lord, kept in Kottagad, his salary was deducted. 2002 April, my lord, and this year, my lord, we were given first rating test.
Yes.
Again, after 10 years.
Now this rating country was the subject matter of challenge.
Yes, madam. Because of 4
No, this Reading entry made in the year flip in 2002. Did you challenge it? No, that is why these are cumulative, it takes a cumulative effect. So the question from the court is whether during the relevant time in 2002, you had put a challenge to this Reading entry.
Yeah, that is not.
2002, it became final. It became final. Now you cannot go back to 2002 and raise the issue of justification of this Reading entry.
This one was, but, yes,
What you are trying to portray seems to be a very reasonable ground that for 10 days delay, you should not have given a Reading entry. But this was done in 2002, and the effects has come later. You should have made a challenge in 2002. You have not done.
then, the one on lower end, my lord, is not think so, my lord.
Then
Then we got it 2012,
yes.
which is after 10 years, my lord. Petitioner was, my lord, detailed for PIT test and higher practice conducted at Assam for Training Center, Depot, my lord.
What is PIT? PT.
PT, my lord.
Hmm?
And he was, but during this kind of training, higher practice, he for ill, my lord. He was suffering from sugar. For that reason, my lord, he was admitted hospital for 2 weeks. Thereafter, my lord, after coming from hospital, he took rest, my lord. Was suddenly, my lord, commander came, my lord, and said that, my lord, you were absent from duty. For that reason also, we the same thing. Signature was taken, punishment, quarter guard, and second reading. Second reading.
What was the punishment? What was the punishment?
Same way, my lord.
28 days RI.
Yes, my lord. During this period, he was kept in quarter guard like a prisoner. His salary was, for that period, was deducted. Second reading, then he was denied. 14 days, my lord.
Yes.
Second reading. Then, my lord, in 2015, he was in journey, my lord. During journey, my lord, he lost his, my lord, during heavy traveling, my lord. He lost his eye card. And my lord, when he, my important document also, my lord. Then his train ticket, eye card, he lost, my lord, traveling from Sarsa station to Mansi station by bus. He fell victim to a theft, my lord. Prisoner lost his eye card, train ticket, some important documents. For that reason, my lord, an answer 3 days to 80, my lord. Same day, same moment he has made FIR. Days to 80, my lord, and answer will file FIR. For that reason, my lord, same punishment was given to him, my lord. It was given, my lord, the third reading. That is in 2015. And in 2019, my lord, when he was doing his duty, my lord, he was detailed. April 2019, he was detailed for ROP duty, road opening patrolling duty, along with others with that. The commander 41 Assam Rifle was coming from the Assam Rifle Training Center, Dimapur. Commander were crossing the road party, he called the petitioner and asked why they are working on the road. The main duty of road party is to provide the safety and security to the army party flying on the road. The commander 41 Assam Rifle sent the petitioner along with other soldiers to the Union Hospital for medical checkup. But nothing was found, but the allegation was given, he was intoxicated. This is in April 2019.
Nothing was found.
Nothing was
Medical
found.
report?
No, but
Where? Where is the medical report? Then how do you substantiate? If that is the reason that you are found intoxicated, it is your case. You have to tell us this is the medical report, nothing is there. And if it is there, it is a wrong report. You have said neither. You have to make out a case.
service. Thereafter, my lord, so called certificate were given September 2019. They have replied to the so called my lord.
Yes. Yes. 22. Yes.
Whether it is considered that the conduct of number so and so has led in getting 4 resident street. Thus as to render his further retention with service undesirable, being an inquisitive offender. Whereas so and so was afforded an opportunity to show cause against the proposed action on 10 September 2019. Then my lord, he has submitted his reply on 6/2/2020.
Hmm?
Same as
Yes, yes, we have read this.
same as and was found unsatisfactory. Thereafter, he was discharged. My lord, my submission is that my lord. First of all, their trading cases, he was already punished for that matter. Already he was given my lord quarter card, punishment, salary deduction, rigorous imprisonment. Again, my lord, he was discharged from time and without any inquiry, without any hearing. First of all, because they have said there no sufficient cause, but there are sufficient cause that other time they inform the department. A lot of sometimes they.
Can you go back to the justification of the red ink entry now? Are you challenging that part of the statute, which gives them the power that in case of 4 red ink entries, they can go ahead with the proceedings of?
There is no such mandatory rule that as soon as you will get 4 ethics, you will be discharged.
No rules.
No rule, my lord. Because, my lord, I have many, my lord, many letters, my lord. Here I give one letter. This person, my lord, having 9 days in country.
No, we are not on that. You should, if you are saying that in Assam Rifles there are no rules, we'll ask the CGC.
Because written instruction, but I don't have, but I know, so this is 9 days. There is no such rule, my lord. And my lord, in my affidavit in reply, I have election judgment, my lord, of this recent judgment. In my affidavit in reply, can we see first and examiner?
Your affidavit.
Affidavit in reply, and so 1, my lord, page 122. 52. First and examiner. In similarly situated person, he was reinstated.
Yes. Now we have.
And here also, because in the, they have, in the reply to the so-called, my lord, we are reading the whole judgment. Exactly, my lord, this is covered.
Now we'll see whether they have got the power or not, now, number 1. And if they have got the power, whether they have exercised this power in accordance with law.
And my lord, judgment of Honorable Supreme Court, I am relying, my lord, for more recent, my lord, in 2022, one more recent judgment.
Regarding?
Clearly says, my lord, there is no such rule. And as soon as he gets the 4 ethics, he will not be discharged. It gives a gray area, my lord.
Let us see. Okay.
And they cannot give him punished twice.
So the Honorable Supreme Court, don't give the others. Memorandum is the latest.
Especially regarding coal rating.
Which paragraph?
That's the analysis.
Here, the underlying aspect was that the petitioner therein, the incumbent did not complete the qualifying period of service. So it was held that it should be treated that the petitioner incumbent had completed the qualifying service period for grant of pension.
But whether
Are you getting pension or not? Then,
that I am not on that, I have completed 27 years, I will definitely get, because 10 years is necessary. But whether the way they have, my lord, discharged me, that is.
no, you have made a very significant submission that the rules do not, there is no prescription in the rules. Yes, that is the thing, yes. So, go on.
If it's not there, but otherwise, because the ROI is there. This is also reflected in the available effectual journal, in the launching journal. So, my lord, there are 10
Of,
currently.
of your, there's another judgment.
My lord, journal also there. Paragraph 10 in respect of ROI basis, cost 5 of ROI. Therefore, the instruction proceed provides that under sector 8, it is in paragraph 10.
Just a minute, please. Balwant, I think Balwant Singh we have referred somewhere.
Endra Kumar is the other estate. It was already noticed as decided that particular issue. In Endra Kumar just noted, there was no surplus of issue also, no opportunity plus innovation. Therefore, my lord has already decided that particular issue. This was already settled by lawsuit judgment on 29/8/2024. Exactly similar section circumstances.
This ROI pertains to Assam Rifles or what?
Was it was for instruction of some issue.
Paragraph 9 you are referring to. 10.
Then, let's see, 12 and 13. 12 and 13 regarding the judgment on
In-
the case was not done from our hand.
Oh, no, it's our complete, don't worry. Which paragraph 10?
10, 12 and 13. Then you also mentioned about the record of the inspection of what type. 12 and 13 was regarding compliance of the procedure. In that case, the procedure was not followed. So I would say that also.
What is this, Binodi? Binodi case of our court?
Binodi was again was delivered by my lord.
Yes, what is it? What is it about?
Same, exactly similar issue, Assam High Court, rating and thing, all procedure was followed. There was a summary trial was there, purpose was given, on the basis of that, my lord was part the order. There also was a summary trial was given also, at no point of time, the idea rating entry was set up before the summary court also. Even if the opposition is given the subject, similar situation.
Paragraph?
Here also the insurance case started from the paragraph 4 also. Then after the my lord said paragraph 12. Paragraph 7 is the summation of the liability of the citizen also.
Here even the pensionary aspect was.
Yes, all the pensionary.
No, in the other case, the submission that he should be allowed to serve at least 20 hours, that was also rejected.
And also in that particular difference, the participant to receive all the functionality. Here also this is functionality question. All the procedure was also followed. And immediately at no point of time, there was, earlier judgment where it was delivered the judgment. There was also no silence regarding it for rating and this question. There also immediately no silence was. There also procedure was followed. Summary file was given with after the statement. Here also immediately seen out.
Yes. Yes, anything reply? One four. Yes.
Ninth line from Gautam.
Yes.
Can we say reliance upon recent judgment of this court in Union of India has an address.
Para 14 you have read. Para 14. 14 starts, it is true. 14 starts, how does para 14 starts? It is true. No, it's not para 14, you're writing something else. Para 20, not 20.
Just that. Virendra Kumar.
Understood. You have given, what are you reading? Are you reading SCC?
There are 1-4 member. Here, here.
Virendra is not there. Virendra is different.
My submission is there. Virendra Kumar just-
Show us, Virendra Kumar, where,
It is clearly written that Balwant
Which-
Singh was.
which paragraph? Tell us. Which journal are you referring to? Your journal, tell us the name of the journal. Online, and you have given this copy, just mark in this copy, it's not paragraph 14.
Required. And it was said that it was misplaced.
Is it 20.4, madam? 20.4. 20.4, yes. Hmm.
So misplaced.
Yes,
So my lord, he is relying on Balwant Singh. There was
no,
my lord here in Virendra Kumar judgment, my lord, it was said that it was misplaced.
no, Balwant Singh was misplaced so far as the facts of Virendra Kumar is concerned. It cannot be that Balwant Singh has been decided to be bad law.
That time he said.
Then, under facts, it is misplaced, maybe. Is Virendra Singh connected to Assam Rifles?
Sir, it's connected to army, otherwise you see in that particular case, no purpose or issue, no possibility in that case, they are in Virendra Kumar cases. That is the reason Honorable Supreme Court says that it is not similar to the Balwant Singh, but because what the Balwant Singh is specifically defined. But Virendra Singh is with the mercy, and no procedure was followed to it, that is the reason also. In Virendra Kumar Singh's case. There is a procedure.
Okay, that you have stated already. Yes.
But then kindly see this Virendra Kumar Pandit judgment. Here also Balwant Singh is there, but he is saying that it is army.
Amarendra.
Please from my lord Assam Rifle, exactly my lord on that.
Yes, which paragraph?
There are 20 to my lord.
Yes.
Must first look into the decision of the court rendered in case of Virendra Kumar Dubey Supra. In the same case, appellant Virendra Kumar Dubey was enrolled as an operator in the courts of Artillery of India. He served in the same capacity for nearly 12 years. He received the super notice, pointed out that he had awarded 4 detectives for various offenses set out in the notice, and that Virendra Dubey had become a habitual offender, thereby setting a bad example of the army. Virendra Kumar Dubey ultimately gave discharge from service by an order dated himself. He preferred a departmental appeal to stay. He thereafter went to the High Court of Madhya Pradesh. However, High Court declined to entertain the petition on the ground of court system. He therefore preferred an appeal before the appeal court, and his appeal was ultimately ordered to be transferred to Armed Forces Tribunal. Tribunal bench concluded. Tribunal ultimately dismissed the transfer petition, which gave rise to this appeal to this court. My submission is that this Virendra Kumar Dubey is also referred in the Virendra Kumar judgment matter. the aforesaid decision, the court took into consideration the fact that there was no obligation of mine by the authority to the relevant aspects which were taken into consideration.
Madam, read
by-
39 and 40, the underlying aspect was to enable the incumbent to have his pension. Para 40 has even said no back wages, just treat him to be in service till he completes the pensionable period. Cannot help you.
And when a loss of ICAR, which is also not under control of the petitioner, who filed FIR. If there goes only my lord, then he remains my lord. Then also my lord, I can be.
But did you challenge it? You have a good ground way of saying that reading entry, 4 reading entries, you are projecting that neither of the reading entries are justified. Why you did not challenge it? In Binu case, we have said exactly that. That if you are aggrieved, see, these will have a cumulative effect. Unless you challenge it at that point, you lose your right. It amounts to accepting.
But I have already told that there is no such rule.
That has been, we have already, we would have considered that, but we have already considered in Binu case. And that instructions, record of office instruction number 1 is clearly clear. Which one?
Yes, 127.
We have already read
Let me
that.
reply.
We have read that.
26 to 2024 is not that time.
Yes.
There are two, the petitioner is given for assignment to the day in the year 2009 after going. to
We have
the-
read this. We have read this.
If proposed notice are listed to
We have read this, madam.
there are 3 of the applicability in reply, and XR 1, page 127. The authorities by letters will after consideration of the reply given by him found his reply to be unsatisfactory, and a decision was taken to discharge him from service. Accordingly, by order director, he was discharged from service, being an incorrigible offender. Being agreed with the discharge order, petitioner approached the Supreme Court by there my lord responded by counter petition. Para 6, my lord, learned counsel petitioner submits the discharge of the petitioner due to poor reading entry service was done in a mechanical manner, and the gravity of poor reading entry was not considered by the competent authority while discharging on 23/5/22. To submit the Honorable Supreme Court in reaction debate, thus my lord held that poor reading entry simply pushes the individual concerned into a gray area where he can be considered for discharge. However, just because he qualified for such discharge does not mean that he must necessarily suffer death penalty. Para 7, my lord. In the present case, it is submitted that poor reading entries in the service procedure which are not serious. Therefore, into normal death so this has to be interfered with. Then this reply, then court considered the advisory issued by the Ministry of Health. Advisory also I have annexed in my applicable reply. After Virendra Kumar judgment, they have issued their own advisory.
The judgment of Binu was considered here. Not considered.
Virendra Kumar,
No, the judgment, earlier judgment of Binu, the Binu. Was it considered? Was it brought to the notice?
the then my lord, on consideration of four rating country, it is seen that he underwent 3 years rigorous imprisonment for the offense, 7 days rigorous imprisonment for the offense of overstaying leave, 7 days rigorous imprisonment for overstaying leave, and then my lord, losing of identity card. Assuming that first 3 rating entry are serious in nature, this court is of considered opinion that the court rating is a matter which needs consideration of the respondents. In instance, the losing of identity card may be beyond the control of the
So it is this last wedding entry was of which year?
Then 19.
And when did you, when was this writ petition instituted? And the last wedding entry was your intoxication, where you do not have a medical certificate. No. If you are saying that you are not intoxicated, the burden is you. Can you shift the burden to them? They are not before the court. They have not come to the court and he is intoxicated. Kindly allow us to discharge him. They have already done their part. If you say that you are not intoxicated, you say either you say that the certificate says that I am not intoxicated, or secondly, if there is a certificate that you are intoxicated, that certificate has not been issued in proper manner. Yes, any record on the last wedding entry? Do you have any record?
Because I know my lord.
No, rule they have already referred, which you have already taken care of, record of office instruction number 1. That pertains to the assembly efforts. How can we insist upon something which is not there?
Then my lord, advisory and regulations also there. And evaluation
May not be necessary. 27, otherwise also you are getting the benefit. You can close this. First, we have got a counsel for the petition. Also heard the Google. Hearing is concluded, judgment is reserved. Yes. Yes. Yes.
Item 6.
Yes.
Government are also yet to find the so there were also subsequent developments, right? Because subsequently.
What is the cause of action?
The junior was promoted. I was not made promotion.
And you have retired when?
31st of March 2023.
You have to argue your case. 2025, we are not adjourning your matter. Argue your case. If you have a case, we grant you relief. Otherwise, we dismiss your case. Yes, government.
Yeah.
Who is for the forest department?
He was promoted on 30th of March 2023.
We have been promoted also. So what is the cause of action now? Under what law? Under what law? Tell us. Promotion retrospective effect.
Junior was promoted from the date of the notification.
Which junior?
The notification.
This phone number? Then what do you gain? At best, if you had in service, we'd have said that fitment or something. You've already got the promotion. Is there actually any cause of action? Or you just lingering with the petition? Let us see your prayer. Come to page 29. Grant promotion forthwith. Promotion has been done. Where is the cause of action now? Which date your promotion has been done? Which date?
30th of March 2023.
30th of March. Promoted as
Assistant Conservator of Forest.
ACF. And when did you retire?
31st of March 2023.
One day before. So you are getting the retirement benefit as an ACF.
But there were some discrepancies regarding the date of birth. So we filed a rate petition. Thereafter, the respondent we accepted the stand of the respondent that our date may be considered as 31/3/2023. Thereafter, the petition was disposed of. The content is pending.
Regarding?
Regarding the pensionary benefit.
You are not getting pensionary benefit.
Subsequently, recently, my provisional pension has been released.
That is a different cause of action.
Different cause.
Now, if you are retired on 31/3 and one day prior you have got the promotion, which was the substantial relief you are seeking, where is the cause of action? We'll have this on Thursday. Mr. Goswami, kindly inform your colleague in the forest department. Thursday we'll have here for disposal, 21 matter. Third, your SVH Agarwal Learning Council for the petition. None appears for the department. The substantial cause of action for which the writ proceeding was instituted in the year 2021 was for promotion from the rank of forest ranger.
From forest ranger.
From the rank of forest ranger to the post of assistant conservator of forest. There is also a prayer, an ancillary prayer to give effect from 26 to 2021, on which person junior to the petitioner was promoted. Full stop. It, however, transpires. This court has, however, been informed. This court has, however, been informed that during the pendency of this writ petition, on 30/3/2023, the petitioner was indeed promoted to the rank of assistant conservator of forest just before a day of his retirement, which was on 31/3/2023. Full stop. As regards the aspect of giving retrospective effect, comma, from the date his junior was promoted, comma, apart from the aspect of not making the said officer or party, comma, the, unless the rules prescribes, comma, whether such a prayer can be considered would be a question. Para, be that as it may, in absence of the learned counsel for the department, standing counsel for the department, no final orders are passed, and the matter is deferred for consideration on Thursday. This event.
Okay, here it is, case lordship, let's compare five lordship, newly included lordship, the SLC, the role is, rule is against this respondent, SLC lordship, but the implemented new, the new post title, that was not, punished to us lordship. After amendment post title lordship, that was punished to us for SLC lordship. I think,
Who appears for SLC? Who will appear for SLC?
I am appearing.
Worship order dated 26/6/2023.
Yes, but the extra copy not
Already appeared.
no, I appeared. But
Mr. Goswami, how does it matter if it was passed in your presence or in your colleague's presence? And only the course title has been amended. How does it make any difference?
But the extra copy to punish the SLC lordship, that is not punishing the lordship.
No, only direction is given to file an amendment process. The amendment process on record.
Yes, lordship, but after amended the prison, the newly the SLC was included lordship. And I took the notice on behalf of the SLC lordship. But lordship, the extra copy not punished to me. No, extra copy is the writ petition for newly included respondent lordship.
And question is, my lord, because they are also education department. But issue is very limited, my lord. Issue is, my lord, district level committee, my lord, recommended my name. But state level committee not allowed. Only this ground that earlier what a person applied and let me. That is my lord ground, my lord. Therefore, my of the bona fide and believe that. Page, my lord, 29.
20?
29.
When was the death? Death was when?
Died 16. Died, my lord, 29 to 2016.
2016, 2025, how can we direct your consideration?
My lord,
After 9 years.
to place the meeting.
After 9 years, what is the objective?
But it is continuing, my lord, since.
No, after 9 years, can you direct your consideration for compulsion appointment? Tell us.
But the question is, my lord, I filed a petition.
You might have filed, but ultimately what? Can you be given appointment after 9 years? For a compassionate ground?
Therefore, my lord, this order was passed at I not that party, SLC.
But in view of the law, in view of the recent law, in view of Tiwari judgment,
My humble submission, my lord, may consider on the next meeting.
what purpose will it serve? Can we give your consideration?
I am suffering because I have.
No,
my
if
lord,
any such direction would be against the judgment of Tiwari.
I have two minor daughters.
That is okay.
Therefore,
When was the death?
I made representation.
When was the death? 2016.
But I made representation on 23/9/2016.
No,
Within the.
all said and done, after 9 years, can we direct?
But it is not my fault, my lord.
Even you're not,
Department not allow, my lord.
before,
I'm
before,
running for office.
Mr. Before you make a submission, kindly read Tiwari. The aspect of fault on your part, aspect of the fault of the department, who both have been taken. We, as a personally, we may not be, we cannot say anything, but fault on others, whether it can be attributed to, but that is the law laid down. Who died? Who died?
Respectful submission, my
Who
lord.
died?
My husband.
What was he?
He was my lord, master ever, my lord, and his post was regularized.
You applied?
Yes,
When?
applied on my lord 23/9/2006.
9/60. When did he die?
died on 29/2/2006.
29 to 2016, husband died. He applied for compensation apartment. Then,
And that has not, my lord, pending, my lord.
They were rejected for the PLC of, they were,
Now, my lord, page 29,
hmm,
GLC recommended.
when,
Here, my lord, page 29.
when, date,
Here, my lord, the minute of the SLC reflect that GLC recommended the candidate, following candidates. And
When was it?
My name was shown,
when was it?
page 29, I'm reading, my lord. The minutes of the state level committee meeting for appointment on provincial ground held on 31st/12/2018 in the office chamber of Chief Secretary to the Governor of Assam State. And now, my lord, below paragraph, the state level committee examined the details of the candidates recommended by the concerned district level committee and recommended the following 4 numbers of candidates for appointment on convention ground. So 1, 2, 3, 4. I am not in there, my lord. But my name appear under serial number 15. Next is, my lord. And here the ground of rejection that applied after Sir Inamul Ahmed for the single admissible vacancy. This is the ground. Whether I lately appear or it is not within the stipulated time, that is not there, but one Enamul Ahmed applied earlier, therefore I am not.
This was when? On 31/12/18.
Yes,
And you came to this court when?
21 years.
now thereafter, my lord, I filed representation for consideration
When?
on 24/5/2019, page 32.
And,
And this is still, my lord, held down.
no, you came to the court in 2021.
Yes.
Why?
No.
Why so late?
When my lord rejected, then again, my lord, I filed an application, my lord, representation.
Where?
That is page 32,
There's 24/5/19.
24/5.
Thereafter?
Thereafter, nothing happened, my lord.
No, from 19 to 21, what did you do?
Well, I'm moving office to office, my lord, but they should consider.
Sorry. We'll dismiss this case. Sorry.
Let's, next meeting.
Cannot do, if it was possible, you could have done.
Otherwise, I am not making delay, because in the year 2016 died, and during that period, I made representation worship, and in the year 2018, rejected.
We would have considered if it was possible within the law. Developer theory is against you.
Not consideration, but
See, we cannot say something which you cannot do.
public, my lord,
We have to dismiss it. Okay.
What?
No, reason nothing. Madam, you are also appealing. Madam Sharma, you are, which for whom? And Goswami for?
4 and 5.
Standing counsel PWD. And you are additional senior advocate. Okay.
Reject ground, my lord, so appear is the impure, definitely no. What ground my there?
No, we would have gone to the marriage if theory was not there. Developer theory is a stumbling block in consideration. You read your developer theory judgment. Even delay on their aspect has been said will come into operation. Because after a long period of time, compassionate ground cannot be, there cannot be a consideration. Okay.